we should have given it to you by 11 a.m. By mistake, I am WhatsApping it. So they WhatsApped it. So it is our fault, Milord.
Very well. It will appear tomorrow একটা order record করে দিন। এসছে যখন
Milord, may I just
this
substitute now?
hearing in this matter was concluded. The converse logic would mean that mere misleading, if there was notice, or mere non-notice may not be falling within the provisos. Second is that if there is an exceptional case made out, undue hardship, subsequent
In the
change,
proviso.
second proviso.
Yes.
So this also has to be considered whether it falls.
Now, Milord, may I very quickly give an answer to this one? This is really why I wanted to come. When I file an application, it's the jurisdiction of the court which is invoked that decides whether it's appeal or revision. Number one. Now, here what am I complaining of? No notice despite lodging of caveat. And therefore, I am saying that it is the act of court which created the problem. I am not.
But then, can the court not cure its own fault by resorting to Order 39 Rule 4 in this case?
No. I am saying that court should have given me notice under 148A, which is mandatory. Court's failure is what I want to bring to the notice of the court, and court will then recall its order. Now, this, my lord, is not a ground under Order 39 Rule 4. Order 39 Rule 4 is the Plaintiff's Act.
Now, let us take it a step further, Mr. Chaudhary.
Yes.
If the order is recalled,
Yes.
ultimate effect is what?
Yes,
Vacation of
that's the second point.
Vacation of the order of injunction.
But that does not matter. That does not matter.
Right.
Effect of the order is not what decides whether it will be
But
appeal or revision.
you are ultimately affected by the effect only. Suppose the court recalls the application and still maintains the injunction.
Yes.
Then what will be happening? Will you not prefer appeal? Suppose the court recalls the order.
Yes.
And then still keeps the injunction alive. Then will that injunction not be appealable under?
No, that would be appealable. But,
Yes,
my lord,
then-
so, my lord, it's a fight between the power invoked, the nature of power
The court
invoked,
does that.
and the effect of the order.
Natural corollary, it may not happen. But say the court finds out a weird reason and says,
Yes.
no, I will recall, but I will still keep the injunction. Then what?
I will
happens?
recall and I am repassing the order of injunction.
Or
That
continuing it. I am continuing it because I find that undue hardship will be
So
there. I
it
will
is-
continue with
so
the
it's a
injunction.
rejection of my ground.
Therefore, both are so intertwined. Which court should exercise jurisdiction? The appellate court, which is the statutorily carved out forum, or the forum which only has superintendential jurisdiction or
So
supervision?
that's what I want to, my lord, show. Kindly, my lord, take paragraph 7 once of this, 6 of this.
Have it then on the next day. They will also come prepared.
May I do it? I'm not there on the 11th. I didn't stand in the way. Just 2 minutes, I'll take. Because I'm traveling, my lord, I'm not there.
Mr. Rai will be there.
Yes. But
Mr. Rai is here with this each. Mr. Rai is here, Mr. Rai is
In the
there,
meantime.
Mr. Rai will be there.
no, just 2 sentences. Your lordship will see the effect
So
of
you will
the
be there on 12th. I'll make it 12th. Not
my
a
lord,
problem.
10th I can, my lord, do it. If your lord
10th they have problem, I think.
এটা চলে
10th I can. That's next Monday I can.
গেটু ডাকো না
করে দে বাবা।
জাস্ট গিভ মি আ সেকেন্ড মিনিট অনলি ওয়ান তুমি বলতে থাকো তুমি দেখাও না
No, but then in that case we'll cut it short. Unnecessarily we'll have half today, half that day.
তুমি 11 তারিখ ছাড়া অন্য দিন আছো তো মানে 11
আমার
তারিখ থেকে
18th.
11 পরে অ্যাভেলেবল অন 18th
I'm not
তুমি
there.
আর নেই 10th আমি পারবোই না
কেন?
এতগুলো মামলা অলরেডি ফিক্স আছে
আরে সকালে করে দিবি এটা ঝামেলা করছে 10th. Some power I should have over my friends
10th
juniors.
at 2.
হোয়াট ক্যান আই সে মিলট
You tell me.
10th
10th at 2. At 10 তারিখ করে দিন। 2 PM করে দিন। নেই তো কিছু?
Grateful.
10th
I'm
at-
very grateful for this chance, Milan.
2 PM
2 PM.
আসবে
এটা ওখানে রেখে দিন।
কথা দিয়ে গেল যাচ্ছে
2 PM 10 তারিখ যিশুরা নেই 11 তারিখে পর 18 তারিখ তুমি তো আমাদের সঙ্গে মিটিয়ে নিতে পারো
ওই আইটেম 1টা কল করে দিন একবার। ফার্স্ট ওভার হয়েছিল উনি ছিলেন।
on earlier occasion your lordship had directed
yes.
to direction.
My lord, I appear on behalf of respondent number 3 and 4, Punjab National Housing.
Learned
I have mentioned the matter yesterday, Lordship, for correction. Lordship, in paragraph number 7 and 8, Lordship, petition.
Yes, Mr. Rai.
Yes. Just before asking my learned friend, I have to say something. Now, my lord, your lordship has seen your lordship's order. This is very clear. And now, my lord, after just your lordship was this order, no application of additional party was filed. That was not pressed. I have given a copy of the application. Oh, secondly, when the application for secondly the application for impounding of that document 1988 old document which was found in 2025 November, that application was filed for impounding, and secondly application was filed for adopting of the plan. Now you will see I have filed a written objection to the application for addition of party. This is very important. Kindly see that written objection. Page 142.
Page 142. Yes.
Page 142. Relevant page 143.
143.
মানে পেজ 142 প্যারাগ্রাফ 4, প্যারাগ্রাফ 4। বর্তমান আকারে প্রণালীতে ও পার্থিত মতে দরখাস্তকারীর উক্ত দরখাস্ত অচল হইতেছে। উক্ত দরখাস্তকারীর পুত্র শ্রী সুরজিৎ রায়, তার পিতা কালীপদ রায় মৃত বলিয়া উক্ত জেমিস মকদ্দমায় উত্থাপন করিয়াছে। তদ্রূপ মহিদুল ইসলাম পিতা শেখ মঞ্জুর মৃত বলিয়া, শেখ নুরুল তাহার পিতা শেখ আলাউদ্দিন মৃত বলিয়া, শেখ মনোজ তাহার পিতা শেখ আসলাউদ্দিন মৃত বলিয়া, শেখ রাজু তাহার পিতা শেখ মালু মৃত বলিয়া, শেখ সাহেব তাহার পিতা শেখ মনিরুদ্দিন মৃত বলিয়া, পুতুল দাস তাহার পিতা শঙ্করগিরি মৃত উল্লেখ উক্ত জেমিস মোকদ্দমা উত্থাপন করিয়াছে। তৎপর মৃত কালীপদ রায় ও মৃত শেখ মালু মাননীয় আদালতে ইংরেজি 21/1/2026 তারিখে উক্ত মোকদ্দমায় অর্ডার 1 রুল 10 ধারা মতে পক্ষ হইবার জন্য দরখাস্ত করিয়াছিলেন এবং উক্ত দরখাস্ত গত 15/5/2026 তারিখে নট পেশ করিয়াছেন। সেই কারণে পুনরায় উক্ত কালীপদ রায় উক্ত মামলায় পক্ষভুক্ত হইবার জন্য দরখাস্ত করিবার অধিকার হইয়া গিয়াছে। উক্ত জেএমবি মোকদ্দমার দরখাস্তকারী সুরজিৎ রায় তার পিতা কালীপদ রায় পরলোকগত হইয়াছে। উক্ত অত্র জেএমবি মোকদ্দমা উত্থাপন করিয়াছে। প্রকৃতপক্ষে কালীপদ রায় জীবিত নাম মৃত, বিনা সাক্ষীতে তাহার অস্তিত্ব সম্পর্কে সন্দিহান থাকিয়া কালীপদ রায়কে অত্র মোকদ্দমায় পক্ষভুক্ত করিলে অধীনগণ প্রিজুডিস হইবে, সেই কারণে উক্ত দরখাস্ত খারিজ হওয়ার যোগ্য। This objection was raised. Now, my lord, this application, after this objection, when earlier it was not paid without giving any liberty, subsequently this application is not maintainable. Secondly, the application for impounding the documents of 88 documents. Now, you also kindly visualize this thing. Their specific contention is that the petitioners have executed the documents sale deed in favor of the predecessor of the opposite party. Now this is 88. Now suddenly they found the documents in November 2025. Is it believable? Secondly, when an application for 151 was filed for injunction for staying of this execution case without putting any signature, verifying the signature, without nothing, when I filed a written objection to that section 151 application, denying that we are not executing any documents, we are not putting any signature, even though after that, my lord, all these 3 applications were allowed. Now your lordship knows the judgment. Your lordship knows that specifically, my lord, this judgment is very important. I am putting this judgment to your lordship. Can you see the judgment?
Yes.
This is, can you see paragraph 73, subpara 42.8. And I am reading that. This court exercising jurisdiction under section 47 or under order 21 rule, order 21 must not issue notice on an application of a third party claiming right in a mechanical manner. Further, the court should refrain from entertaining any of such application that has already been considered by the court while adjudicating the suit, or which raises any such issue which otherwise could have been raised and determined during the adjudication of the suit if due diligence was exercised by the applicant. Now 42.12. The executing court must dispose of the execution proceeding within 6 months from the date of filing, which may be extended only by recording the reason in writing. No, 74, para 74. The mandatory direction contained in para 42.2 in Rahul S. requiring the execution proceeding to be completed within 6 months from the date of filing, as has been reiterated by this court in Bhojraj Garg versus Goel Education. Now, my lord, my execution case in 1989. Meanwhile, my lord, again, the order 21 rule 97, why that was dismissed, 47 dismissed, police cost was deposited. Just at the knocking of the door, when the execution degree will be executed, that moment, stay of the execution. Now, when your lordship passed this order, that stricture order, that if you do not dispose of this application, Jimmy's case, by 11 June 2020, 5, 6, then you will proceed this case. Now, after the James case, the entire evidence was closed in the James case. Kindly see this order. James evidence in entire closed. Thereafter, all these applications were allowed. Kindly see this order. Page 220. Sorry, order number 220. Kindly see this order. Evidence has been closed. Order number 220. Has you also got it? Order number 220. Last but one page. Order number 220.
Yes.
Kindly see. On careful perusal of the record, it appears that the James case 116 of 2025, in respect of the compliance of the direction of the Honorable Court, being serial number such and such, after fixing the date of hearing on consecutive days, the evidence of both sides have been completed and record is fixed at present for report of stamp duty collector.
Yes, Mr. Rai.
So I'm starting from the impound portion.
How will you maintain the application? Once it has been not pressed, how will you maintain the application?
I'm not pressed.
Yes.
My lord, if you logically consider whether the not press amounts to whether debarred me from
It is public policy, Mr.
my lord,
Rai.
public policy, my lord, the court is
It
supposed.
is not res judicata. It is public policy. You
Now
cannot
the
come
public-
to the court at your will. You will come, you will withdraw, and then you will file again. That can't be permitted. And it is the same person who had done it.
Now, my lord, can you consider the earlier application? What is the earlier application filed?
It was application for addition of party, whatever may have been the reason. Whatever may have been the reason. How will you maintain this application?
Yes, my lord.
Your subsequent applications are on the basis
Now,
of
my lord,
this
can you consider what is the reason assigned for the purpose of allowing my application? Irrespective of whether order 1 rule 10.
The only reason which I could find yesterday was that the application has not been decided on merits.
Apart
That
from
is
that,
not the reason.
apart from that, if a agreement, my lord, can you consider the person who has been intended as a party is a party to that agreement. If the court has to pass a degree,
He chose not to assert his right. when he
it is the
withdrew
court's manner. That is why the court's finding is that his presence is necessary.
through the application without liberty to file afresh.
Man, that liberty, man, if you logically consider order 23 once, this relates to my lord, if you logically consider withdrawal of suits or abandonment part of claim.
Not I just say even if order 23 rule 1 does not apply, the principle of public policy applies, which has been extended even to writ petitions.
Man, the public policy, my lord, if you logically consider only on the ground, my lord, to what extent? If you logically consider
the extent, because it is evident this application was filed in May. He withdrew this application immediately at the point of time when he sees that the James case is on the verge of closure. He files the same application again, and the court is allowing that.
court allows that the presence of that person is necessary. It is not a case, my lord, if you logically consider. It is not a case the person who intended to make party is not a necessary party. If that be so, my lord, not a thing.
Even if it was a necessary party, the person had made the application, the person did not press the application, it was dismissed as not pressed. Public policy will say that it should not be pressed. It should not be. He should not be added again. Why should he be added again at this juncture? There was time for him to be added. Why did he withdraw in the first place?
Yes, that is why the conceptuals of the earlier application man considered. Here, man, both the parties are escaped. Subsequently, it appears man, the Malu died. So that is why that application was withdrawn. It is not that on that aspects. Now, man, if that be so, then the proceedings has been carried out by the parties.
This gentleman, Kalipoda Rai, he himself made the application and he did not press it on 15th.
Yes, man, under what ground? Subject to rational, my lord. It is on the ground that both the parties, my lord, that is why the typographical error and sons have been described that the suit was filed on the basis of that late Kalipoda Rai. It was the ground. If today Manar Kali consider
whatever may be the ground, so what? They made this application, they could have been added as party there and then. They allowed the suit to proceed for such a long time. And
no, Manar, this application was filed, Manar.
Mr. Rai, even otherwise, I have, where is that application which has been filed? Yesterday I noticed something. Where is that application?
The earlier application was this present.
The present application.
Present one.
Page 43.
143.
143.
No,
143 is their objection. Your
Page
application
128.
120.
120.
120.
Yes, kindly come to 129. What does he say? He came to know about the suit on 4th of June 2026. Now come to the earlier application that has been filed. Is this the case made out by him? He did not know about the suit. How did he file the application there then? Will the court allow this application now? Mr. Rai, will you be able to support this? Look at the ground that it has. This shows the frivolity of the application, Mr. Rai.
4/6/2026.
Yes, and this application was withdrawn on 15th of May 2026.
এটা 4/6 বলছে 4/6.
On this ground of falsity itself, it should go. On the ground of falsity itself, it should go, even if the public policy doctrine is not applied. Difficult, Mr. Rai.
That was not. So far, the impound portion is concerned. The court has the.
He has made a false statement before court saying that he did not know. He filed an application on 15/5, withdrew it 21/1. He filed it on 21st of
21st
January,
January.
withdrew it on 15/5, and then says that on 4/6 he got knowledge. How did he say so? Liken it. Reason that yes, I personally feel that he is necessary.
Yes, that is what one precisely one can consider.
Court says it was not considered on merits.
Last paragraph, my lord, order impugned on
Yes.
careful perusal of all material records, keeping in mind the solemn direction of the Honorable Court to dispose the James case, that they have parted that Kalipatra is a necessary party in James case, without whose presence the dispute could not properly be adjudicated. My lord, Kali, pause there for a moment, and my lord, Kali, consider irrespective of application. In absence of any application.
His application was for his interest. The court has supported his interest by ignoring the averment which was falsely made by him.
It is a court.
This application is for his benefit only. This application
It is
not
for the degree. My lord, Kali, consider it is a 5 degree. The document executed in favor of 5%. Whether the part degree can be passed. My lord, can pause there for a moment, and my lord.
no question of part degree.
Yes, my lord. If that we show, my lord.
Was so cautious about his rights. He ought to have come at the right time. He has lost it. He has waived it.
That is why that is why, my lord, if you logically consider order 1 rule 10 once, subject to say, my lord knows, my lord have got number of times, my lord, order 1 rule 10. It is the court's
Very well.
at any point of time.
Courts is there. Court's power is there. This does not appear to have been exercised in such a manner where it was so necessary that he ought to have been added, despite him himself saying one thing at one place and the other thing at the other place. That is not how
So that portion has been ignored. Ultimately, the court's finding is that he is the necessary party.
on his application. On his application.
Yes, but,
That is on his application.
but
court has
the
made
finding,
a
ultimate finding is on that basis. It is not that.
Be like this. The petition the execution case should have been proceeded. Why does he stall the execution case and post it after the James case, after the direction of this court?
Yes, my lord, subject to cash, my lord, if your lordship kindly consider.
When is the next date?
Next year, 18th August.
18th August, execution will proceed. Whether the Jamis case is concluded or not, whether the impounding is there or not. Likhun.
If your lordship, my lord, kindly consider my lord's order.
Yes.
My lord's order is very
I
clear.
have said it will not be stayed without recording any reasons. This is a deemed stay if he is not taking it.
My lord, kindly turn to page 122.
Yes.
Paragraph 8, my lord, kindly turn to page 184.
Yes. Yes, paragraph 8.
The court informed that June 11/26 is the next date fixed for execution of the case. In such a view of the matter, the court requests the learned executing court, being learned civil judge for such and such, as if it is possible prior to the date fixed for execution of that case. So court proceeded for disposal of the execution on the basis of which that application was considered and disposed of.
Where is that application for stay which was considered and disposed of by the court, by the trial court, saying reasons?
And it's the next para. And it's the next para. He's not reading the next para.
My lord was pleased to reject that application stay.
Yes, then
That is why
he
there is no
then-
direction for reconsider. Only
Yes, that is what I'm saying. That if there is no stay, then in that case the court could not have put it off. That the Jamis case will and the execution case will go hand in hand. He will wait for execution case for 10 years to come, but he will execute the decree in the meantime. And if he feels that
it is a direction. That is why your lordship was pleased to direct that this case will be decided prior.
he has not done it. He has not done
The
it.
reason is beyond control or not. That is the only thing. My lord,
He
your
has not
lordship,
done it.
in one hand, my lord,
Therefore-
if your lordship kindly
therefore-
consider.
The learned trial court cannot have based off. He will proceed with the execution case after finishing the Jamis case. That was not the direction.
Now, kindly see paragraph 9.
Doing exactly that.
But kindly see paragraph 9 of your lordship's order. Paragraph 9.
Doing exactly that. Once the court directs that no, you will have to proceed with the execution case, notwithstanding what the result of the Jamis case is, he cannot put the execution case off. And that is what he has done. It cannot be decided. Who said it cannot be decided? There are means and ways by which execution case can be decided earlier. If the Jamis case, if you feel that yes, it is so meritorious.
If you logically consider. So that is why your lordship, while rejecting the stay, my lord does not grant us to apply for fresh stay for deciding on merit whether I have a meritorious case or not.
required.
Then, my lord, in one hand, your lordship was pleased to direct that the execution case is proceeded with, and in the other hand, my lord was directed that whether this
What
application
was the idea then, Mr. Rai? The idea was that the execution case should not be stalled because of the Jamis case. Now, what is the result?
no, my lord,
Fixing both the dates together. What is the use?
my lord, otherwise, my lord, if you logically consider 2199 and 101, it is a threat of disposition.
Mr. Rai, for an 89 decree, if he executes his first and gets it restituted, it is very well, because it was your duty also to come up at the appropriate time with a 1988 agreement. Even if I proceed on the basis that the agreement is absolutely enforceable, absolutely legal and valid. Because a person who has sat on his agreement from 1989 to 2026 cannot be now set to heard and said to be saying that a decree of 89 should await the order 21 rule 97 adjudication. That cannot be the law.
Still, we are on the threat of disposition. That is why, my lord.
Right. You should be, because the decree of 18, you did not assert your right on the basis of the agreement since 1989. Once he gets a decree which has sustained challenges up to second appellate court, not carried to the Honorable Supreme Court, two execution applications, two applications posing hurdles in the way of execution having been dismissed. Should this person look at this person? From 89, he is holding a decree which is in just in the form of a paper.
Then, my lord,
That
then, my lord, if you logically consider it that way.
if you were so confident about the document which you say was procured in 1988 or 89, that it is so valid and legally enforceable, you should have asserted that right at the appropriate time. You waited for more than 36, 40 years.
Yes.
And now, after in his execution, you want to stall it. How can the court come to your rescue, Mr. Rai?
It is not the rescue, my lord. So far, this is which is the document which is before your lordship.
কালকে রেখে দিন for orders tomorrow. লিখে নিন।
And if your lordship wants that As your lordship says, the public policy is not guided, but in view of the wrong statement, my lord is.
He is,
Yes,
even
yes,
if-
that is why I'm not.
even if for the time being I discard public policy, although I am sure public policy will apply here, even if I discard, your own document shows that it should not be entertained. It should not be entertained because this cannot be improved. Nobody can improve it. He himself says that
Yes,
on
yes,
5th
yes,
of
yes.
January, on 15th of May, he withdraws. January, he
If
finds,
21st January,
says that now in June he got knowledge.
yes, there,
This
I'm not joining issues over that. Please discuss.
लिखे नहीं? Heard Mr. Dotto, learned advocate.
My lord, I am for the petitioner, my lord. My lord, I am led by Mr. Shomojit Das Mahapatra. My lord, he is on his legs before court 35, my lord. I am starting the matter, my lord. He'll join, my lord.
What do you want, madam?
My lord, this is the affidavit of service, my lord. On previous occasion, my lord, when the matter was taken up before Honorable Justice Ravi Krishnan Kapoor, my lord, it was dismissed for default. We could not appear, my lord, because I was engaged in another court, my lord. So we have filed a restoration application, my lord. Kindly restore our application.
The restoration. लिखे नहीं.
My lord, this is also, my lord, for seeking for new electricity connection, my lord.
Where is the application for restoration? এখানে can আছে নাকি?
Yes, my lord.
Can one.
My lord,
Lordship, kindly, ताले तुम्ही बोले ना. May kindly allow me for a moment. Lordship, kindly allow.
Answer the
Yes.
question. Where is the nexus?
But there is a nexus. If your lordship kindly see, from the paragraph
2 onwards. Paragraph 1, may I place it?
There is only one page report.
No.
Yes.
There is
In
no
the records of the file, there is only one page report. Nothing more.
4 pages report. 4-page report, Lordship.
It's not there.
It's not there. May I hand over?
এত কোনো report
May I hand
নেই।
over one report? I'm sorry. Kindly.
There is no recording also that you have filed the report.
I have filed the report and they have taken exception to that. Anyway, I'm placing that report before Lordship. Probably it has been misplaced.
Yes.
May I place it? The petitioner Sanjoy Das,
Where are you placing?
my report from the
Yes.
paragraph 1, Lordship. The petitioner Sanjoy Das is a practicing advocate of Bongao Subdivisional Court. It means the petitioner, knowing fully well about the outstanding due in the premises, has purchased the said property from the seller, out of which one of them are also advocate. These seller, interestingly, have not met the parties in this instant. They are not parties in this instant writ petition, Lordship. The interesting part are that these seller have got no electric connection of their own. These seller have purchased the said property from, kindly take note of this name, then I will show from the writ petition. Tanmoy Bishwas, Raja Bishwas, Horendranath Bishwas, and Baul Bishwas being legal successor of Anjali Bishwas. Anjali Bishwas was the original owner of the said property who died intestate on 11/6/2001, leaving behind the aforesaid person as a legal successor who sold the property to Sujit Devnath, Babu Kori, Molay Mollik, and Sumit Poddar. These person have got no, these person are the seller of this petitioner. These person have got no electric meter in their name, and they, knowing with a malified intention, sold the property to Sanjoy Das to the petitioner herein. In a paragraph, page 14 to 16 of the writ petition.
Let it appear for hearing then.
Yes, and Lordship, I will show from the document itself, they have purchased the property and the name of those person are appearing in this document. And that is almost 20 lakhs dues. And I will show from the regulation itself, even if there is no nexus, if connection is to be given to anybody else, that dues has to be cleared out.
Which regulation?
Electricity Regulation 2013.
What is the name of that regulation? The Regulatory Commission is the
Yes.
parent name. The main name is Electricity.
Notification is the 55.
No, it is Electricity Supply Code, Performance of
Supply code,
License.
Lordship. Supply code.
That is the name of the regulation.
Supply code. West Bengal Electricity Regulatory Supply Code, dated 7th August 2013. I am drawing your Lordship kind attention to 4.6.4. There was a deemed terminations. Your Lordship knows 180 days over. And on that basis, if your Lordship kindly come to 4.6.4, notwithstanding, I am emphasizing on that. I will show the judgment also. Non-obstinate clause is there. Content contrary elsewhere in this regulation, even there is no nexus or nexus, where deemed termination of agreement had taken place, then on basis of application for any consumer, new service connection can only be provided in the same if the outstanding.
Your Lordship would kindly take up this one. This is how this property has been handed over. In this matter, this property originally belonged to this Anjali Bishwas. She died in the year 2001. There was a connection in her name that got disconnected in 2012. There were 4 heirs of her. Tanmoy Bishwas, Horendra Bishwas, Baul Bishwas, and Raja Bishwas. Tanmoy Bishwas had a connection that got disconnected in 2013. Raja Bishwas had a connection that got disconnected in 2017. Now, from them, Sujit Devnath, Babu Khuri, Malloy Mullik and Sumit Poddar got this house. Your Lordship would kindly come
Did
to.
they take connection?
Huh?
Did they
No,
take connection?
no. This is the thing. This is the actual.
That is why regulation 4.6.4 of the supply code regulation kicks in.
I'll show to your Lordship. Your Lordship would kindly mark that when was the last disconnection happened? 19/11/2017. Thereafter Sujit Devnath, Babu Khuri, Malloy Mullik and Sumit Poddar has purchased this plot. This was purchased in 2022. Your Lordship would kindly take up my affidavit in opposition.
Yes.
Page number 10.
Page 10.
Page number 10.
Yes.
From third line from the top.
Yes.
Just last. অত্র বিকৃত সম্পত্তি সম্পূর্ণ নির্দায় নির্দোষ এবং মুক্তাবস্থায় নিজ নিজ দখলে থাকাকালীন আপনাদের নিকট বিক্রয় করিয়া বিকৃত সম্পত্তি হইতে চিরতরে নিঃসত্ত্ব হইলাম। This deed is of Sujit Devnath, Babu Khuri, Malloy Mullik and Sumit Poddar. This is, and my deed is a consequential deed. My deed is at page number
17.
page number 18.
1.8.
Main application. 17 you Lordship would see page 17 bottom portion of my application of my read petition.
Page 17, yes.
Page 17 bottom portion. বিকৃত সম্পত্তি বেসরিকাত নির্দয় মুক্তাবস্থায় আমাদের খাস দখলে থাকা অবস্থায় আপনাদের
Very well. That is a covenant between you and your vendor. That does not overrule the regulations.
That is right. Now, my lord, what they have to show two things. First, there was a nexus.
If there is a deemed termination of the agreement after 6 months, nexus goes for a toss. You have to pay in terms and regulation 4.6.4 of the supply regulation. Supply regulations.
But you would see section 56.1.
56.2 is irrelevant for this purpose. 56.2 is irrelevant for this purpose because 56.2 is when you go to the same consumer. So you are a new consumer. 56.2 will not apply because you are not the same consumer from whom they are demanding.
I am not.
So therefore you are a new consumer. 56.2 is not applicable to your case at all. Now, this is a case where a new person has come, seeks electricity in respect of the premises where there are electricity dues, and there has been a deemed termination of agreement. Now, how do you deal with 4.6.4? You have read 4.6.4.
Your Lordship would kindly come
answer
to
that only.
Yes, I do have. Your Lordship would kindly come to regulation number 3.4.2.
3.4.2 is overridden by 4.6.4.
3.4.2 says the licensee shall be eligible to recover from a new and subsequent.
Said, have you read 4.6.4? Please, I have read 4.2. That is why please come to 4.6.4.
Yes, my lord.
Yes.
এটা কোথায় গো রেগুলেশনটা দাও
না আমি দিচ্ছি
না আমার কাছে আছে notwithstanding anything contained.
Now, notwithstanding anything contained takes care of your 3.4.2. Now you proceed.
Notwithstanding anything contained contrary elsewhere in this regulation where deemed termination of agreement has taken place, then on the basis of application for any consumer, new service connection can only be provided in the same premises if the outstanding dues against the deemed terminated consumer is cleared along with the late payment surcharge. Your Lordship, first thing first, this is my interpretation. First,
after Paschima is the first with which it began, that if you have regulations, even if it does not form a charge on the property, Justice Ravindran's judgment, which was the first in point of time 2009 or 2010.
I am carrying that judgment.
That was the first where it says that even if law does not say, regulations say licensees will be well within their rights to assert the regulations and say that this is a condition for supply. I will not supply to you electricity till such time that you clear the dues.
Would your lordship kindly go through this judgment once? This is passed by my Lord Justice Shobbaschi Bhattacharya. This has taken care of this situation. আমারটা দাও। My Lord, this kindly bear me.
কি জাজমেন্টটা রেফারেন্সটা বলো।
মৌমিতা ঘোষ এর আগে দিন আপনাকে সাপ্লাই করেছিল
না দেয়নি।
না ইয়ে দিয়েছি প্যারাগ্রাফ নাম্বার 6 your lordship would count 6 I'm reading for your lordship. Upon considering the submissions of learned counsel and going through the materials on record, it is clear from the deed of conveyance by which the petitioner and her spouse purchased the property. Here also same. Annexed as Annexure P1 at page number 16 of the writ petition that no encumbrance with regard to default in any electricity charges were mentioned within the four corners of the deed of transfer. Rather, the said document clearly stipulated that the purchasers were indemnified against all estate and encumbrances created by the vendors or any person or persons lawfully or equitably claiming from, under, and in trust for them. Your lordship would kindly come to 14. 14. My lord, precisely such a clause was incorporated in the purchase deed of the petitioner and her spouse. It was specifically provided in the registered sale deed that the purchasers were indemnified against all encumbrances created by the vendors or any person or persons lawfully or equitably claiming from the estate. Moreover, the said judgment is not a precedent on the West Bengal Electricity Regulatory Commission regulations, which are applicable to the present case. Insofar as the division bench judgment in Sri Nirmal Kumar Mondol and in the unreported division bench judgment, both cited by the WBACDCL, are concerned, it was reiterated in both the said judgments that the distributor can insist upon fulfillment of requirement of the rules for the effective supply of electricity. 22. In all the cited judgments, the courts have insisted upon the rules and procedures being followed.
Yes.
If even agreeing to such proposition, it is evident from clause number 13.9 of Regulation 46 of 2010 of the WBERC that no nexus with the previous consumer and the purchaser was established by the WBACDCL, nor could the WBACDCL show from any material that the purchasers had benefited from non-payment of the aforesaid outstanding dues. The purchasers only came in possession of the property after the purchase, prior to which the alleged default had been left outstanding by the vendor. The sale deed indemnifies the purchasers as discussed above. Moreover, there was no question of the purchasers deriving any benefit from the default or having any nexus with the purchasers. Furthermore, it is well settled that new allegations cannot be furnished as ground of subsequently in pleadings filed with regard to a writ
That is
petition.
a different.
That's a different.
That is not relevant.
Although several allegations has been made in from the bar as sought to be indicated affidavit of opposition, so and so. Hence, the WBACDCL cannot be permitted to insist upon payment of outstanding dues left by the vendor from the purchaser for giving new connection. In such circumstances, it was set aside. Your lordship would kindly come back to that step by step how this ownership has changed.
No, I understand. You have no connection, you have no nexus. You are a subsequent purchaser. You have purchased the premises in respect whereof there are outstanding dues. Whether you can be made liable or not in terms of the regulation, that is the only question. Now, there is a regulation which says you can. This regulation did not fall for consideration before the Honorable Single Judge in this case. In this case, what fell for consideration was 13.9. This was neither placed nor this was considered. Now, in a case where 4.6.4 is placed and 4.6.4 is something which has a non-obstante clause and which absolutely fits in your case, whether you can still wriggle out.
Your lordship would kindly appreciate one thing, that this was my interpretation was different. I may be wrong. Still, in as per section 56, this was recoverable. This is an act. This is not regulation. This is an act. This has an overriding effect. Section 56 says that this has to be recovered within a period of 2 years. 2017
From whom?
from,
Recoverable from
from
whom?
Raja Bishwas.
Yes.
Who was the last?
So you are aware, Mr. Counsel, that a law of limitation is a law of prescription.
Exactly.
Which bars the remedy, not the right. Now, remedy may be barred against that person. If there is a remedy available against you, why will the licensee not invoke that?
Your lordship would appreciate one thing, that why
56.2 will have to be read in the context of the person who is the defaulter. Read 56.2.
56.2, notwithstanding, may I read 56 as a whole?
Yes, of course.
56. Where any person neglects to pay any charge for electricity or any sum other than the charge for electricity due from him to a licensee or the generating company in respect of supply, transmission or distribution or wheeling of electricity to him, the licensee or the generating company may, after giving not less than 15 clear days notice in writing to such person, and without prejudice to his rights to recover such charge or other sum by suit, cut off the supply of electricity and for that purpose cut or disconnect any electricity supply or other works being the property of such licensee or the generating company through which electricity may have been supplied, transmitted, distributed or wheeled, and may discontinue the supply until such charge or other sum together with any expenses incurred by him in cutting off and reconnecting the supply are paid, but no longer. But no longer.
When a person neglects, when will you neglect? Can you neglect if you are not a consumer?
Exactly.
That is why precisely that is why this does not apply to you. Section 56 does not apply to you. Section 56 applies to a consumer. Who is a consumer has been defined in the Act. Consumer is a person to whom electricity is being sold. It is yet to be sold to you because there is no contract between you and the licensee.
Because in between there is another purchase.
Maybe with you there is no privity of contract. You are yet to be a consumer.
Exactly.
This liability, I mean this limitation would apply if you were a consumer, you had neglected to pay. When will you neglect to pay? You will neglect to pay when a bill is raised and you refuse or you don't pay. Then there is a question of neglecting to pay. No bill is raised because you are yet to be a consumer. This is a condition for supply being granted to you. This is a condition for entering into a contract. This is a condition which is imposed by the licensee, which if you fulfill this licensee will agree to enter into a contract to supply electricity to you. So this section 56 cannot be imported in the facts of your case. This section 56 is in a case where there is already a contract for supply of electricity existing, and that has snapped because of your failure or the consumer's failure to pay the electricity dues. In a case where a contract is yet to be entered, you want the electricity authorities to enter into a contract with you. They are stipulating this as a condition of entering into a contract. Whether in this situation, section 56 can be imported.
Two submissions from my side. First, going by 56, it was their duty to recover that within 2 years. Which till date they haven't done anything.
That is different. That does not give you a right to evade what is there in the regulation.
No, that is one thing. Second, why this 4.6.4, what he is relying on, why 4.6.4 is in this place? Because the language of the regulation itself says that if it's vitiated by way of malafide intention, if there is any nexus means there has to be a malafide intention. Malafide intention for what? Malafide intention to avoid paying anything. The example would be, I don't need to say this still, but the example would be, suppose I have handed over my house to my junior. There is a 30 lakhs pending due. I have handed over to her in lieu of 5 lakhs. If this is the case, how she has been benefited? She has been benefited for 25 lakhs. This is first, and the price of the house. Well, this is called nexus. There has to be have a malafide intention. In this case, this is my respectful submission.
That there is no nexus, there is no malafide.
No,
Therefore-
no nexus,
therefore-
no malafide, and the last disconnection took place in 2017,
Therefore,
which
56(2) bars the electricity licenses from recovering it from you.
from no 56 debars him from filing any suit against them, and now they are expecting that someone who has purchased, they will recover it only when a subsequent application has been filed. Only when subsequent application has been filed. This was statutory right of them.
This regulation has been coined in the interest of general public. It's not that. If you read the older judgments of this court only, one I can name Rashi Metals, where this Rashi Metals, where this court had held that
Justice Girish Gupta.
if electricity dues are not paid and they continue to remain unpaid, they will form bad debts. If they form bad debts, they will form a quotient at the time of forming the tariff rates, concluding the tariff rates. They will factor in there. So what will happen as a result? As a result of those bad debts,
Society.
Per unit,
Society.
per unit,
what a person should have paid, the society at large will
Society
have
at
to
large
pay.
has to be given.
Therefore, it was held there that even if you purchase a premises, you should be cautious enough. And if you purchase it with a blind eye, with your eyes closed as to what are the electricity dues, you may be held liable because the purchase itself may be an excess good enough. But then we will not go that far in view of the subsequent pronouncement of the Honorable Supreme Court in Uttaranchal, which came in 2009. 2009 is Pashchimanchal,
2009.
Uttaranchal, Pashchimanchal. Then there was Uttaranchal, then there was Haryana, and we graduated to it.
One thing's
Now, all these judgments in Pashchimanchal, it was stated, which came in 2009, that no
regulation.
licensee can stipulate conditions. Now, this is one of the conditions stipulated. What is wrong in this condition? They have stipulated this condition. You are bound by the condition.
And one lordship, I just
what is my submission? আপনি জিতে গেছেন।
না জেতা হারার জন্য
what is troubling in this situation is that I have in that case I am being punished for no wrong, just because the electricity authority was sitting tight.
No, you can't say sitting tight. Somebody
they are sitting tight for last 10 years.
Ma'am, one thing subject to lordship kind approval.
Yeah,
that
just a minute. Or no wrong. Yes, this is a nice point. Yes.
Since now limitation has started, they cannot
You are
recover.
a third party,
this is
irrespective of whether limitation has started or not. You will say that you are being punished for someone else's dues. So your argument will not. If you make this argument, then limitation is irrespective of limitation. You are being punished. Even if within limitation they had asked you, you would have said the same thing. That why should I pay you? Go after the persons who have walked away with your dues.
I'll explain myself to my facts. This situation is like that. If someone is legally doing hawking in a place, and suddenly he came to know that the erstwhile possessor who was there, there is some due. Now he has to pay. It will start only when I.
Very well, I understood. Anything else?
No, that's all.
Yes,
One thing in non-obstinate clause where I am emphasizing, there is a judgment of non-obstinate clause.
Yes, that
Yes.
is settled.
Your lordship knows that I am just citing subject to lordship kind of approval, paragraph 32 and 33. Yeah, 2009, 2005.
Yes.
Paragraph 32 and 33. That is a non-obstinate lordship. This is a well-settled proposition. It is the protection which has been given. And just now it has fallen from your lordship about the Rasi Metal case. And on that basis, he should, when he has purchased the property, knowing fully well that the previous, আমি তোমার কথা বলিনি কিন্তু, আমি বলতে দাও।
Here I join issue. Here I join. Knowing fully well.
I am telling you, Lordship, I am telling you, Lordship, knowing fully well there is no existence of electricity connection from the erstwhile seller, and from the seller, he knows that there is no connection. So he should have inspect that property, the whether there is any outstanding dues or not. Nothing has been done. Kindly consider that what he has, one is 6 equity, must come in the court with a clean hand.
WBCL.
He is saying it is very unheard of, the old property.
WBCDCL.
Yes, enough.
What WBCDCL is now pleading for caveat emptor. This was their statutory right. This was their statutory. Should I say that this is a legitimate expectation that whenever another person will come in this place, then I will punish this person. Then, this is something they haven't followed the statute. Now they are taking shelter of regulation.
Yes.
Much of this.
And why did you not go against the persons whose dues it was?
Till that
There was a deemed terminations, and on that basis, after 180
There
days,
is a deemed termination that does not stop you from recovering your dues from the person.
but
Deemed termination
because
of
they
the-
have already sold it out and gone from that place, and the person who have taken the electricity, who have
The electricity, first electricity disconnection was done in when,
17 and
17 Lordship,
after
subsequent in
2017, what
2022.
steps did you take?
steps, so far the steps is concerned, your Lordship, after disconnection, no further new electricity has been given to anybody.
Even then, you should
But the
have also
provision,
placed-
Lordship, provision mandate us.
Dr. Sahara, this is a court of equity.
The
You will
court of
also have-
equity,
You will also have to consider your stance as a public utility service
I appreciate,
considering the definition
I
of the
appreciate,
state
I
under
appreciate,
Article 12
Lordship,
of
I
the
appreciate,
Constitution
but
of India.
Lordship,
You will not go against the person merely because this is a provision for safety. It is not a provision which is to be utilized as weapon. It is a provision which is to be utilized as a shield. Now, in this case, why should you not be called upon to show your bona fide that yes, I pursued the claim, for some reason he has become gone missing, he is not traceable, but yes, these are the steps which I have taken. What
Kindly allow
mile
me.
have you walked?
Kindly allow me.
Let me finish, then you will
I
be
understand.
getting
Yes.
an opportunity. What mile will have you walked against the person, behind the person who has walked away with your dues? What have you done to recover the dues as against that person? You are falling back upon him on the basis of the regulation that you are now showing. But what are the steps that you have taken against
I
the
tell you,
defaulter?
Lordship, in truth, that so far the 3 persons are concerned where there was an outstanding due. Initially, there was an outstanding dues. These meters which has been installed, there after the disconnection, they were not traceable. We cannot claim the money from the person where there is an existing meter. Suppose A, B, C, D have got the meter. Lordship, kindly appreciate. Now we have got the outstanding due against the A. The meter has been disconnected. He was not staying in that place.
Where is that case? Where is that case?
That
laid out
case,
by you?
that then they have to go through the evidence also.
Yes, of
And
course, you have to
Lordship,
show that this is a writ petition where you have to show, at least when you say that there is nexus, when you go for
And-
a nexus study, why would you not place it before the court, the steps that you have taken against the
Lordship,
default
Lordship,
criminal?
kindly appreciate the,
Not sit tight
and Lordship,
then haul up somebody who has
but he has not hauled up. He has not come with a clean hand. He has not come with a clean hand.
The premises.
He has not come with a clean hand. Why I'm telling you, Lordship, he has taken the property from a person who has got no electricity connection.
There is no law which prohibits a person from taking a property from a person whose electricity connection is disconnected. Therefore, this is no illegality. I can also purchase a property from a person whose electricity line is disconnected. There is no
But
prohibition on
then
that.
when he sought
But there
for
is
the
your
electricity
duty-
connection,
There is your duty, there is a duty cast on you to go against the person, go for the person who has walked away with your dues. What have you done to that?
so far, Lordship, kindly consider this issue that whenever the disconnection, I could have been tossed out that if the disconnection has been made, subsequently I have given connection to anybody else. New connection has been
That
given.
is neither here nor there. You want your dues to be recovered.
But
What
regulator,
steps did you take to recover
regulation
the?
clearly specify, Lordship.
Maybe
regulation
specifying
has given
regulations may be specified,
that-
we will read it in appropriate manner. But first of all, you have to satisfy the court that you have also taken, this regulation cannot be taken as a sword, cannot be used as a weapon.
But they cannot, but this is the huge amount of outstanding.
Whatever it is, even
Now,
if it is
if
1 rupee,
anybody is coming,
merely because you are a company, you are an electricity utility company, therefore you will sit tight. There is a regulation, you will not go against the real defaulter. Somebody who purchases, you will go
from
after.
where we'll recover?
one-
Lordship has got
where
vast
is
experience.
You have to show.
Lordship has the vast
You have to show-
experience.
You have to show that you have done something as against the person who has defaulted. What is there to show that? What steps have you taken against the defaulter? This is a genuine question which can be put to you and should be put to you. You cannot just fold your hands and say that, no, I will not give electricity. There is a regulation in place. You pay, I will not go against him.
I am not saying I am not going.
You have not gone.
No, I am not going.
All these years, you
I
have
am not
gone.
going that again. There cannot be
2017
charge over the property.
2017 to 20, those are all legal points. On facts, where have you gone against them? This is a question which is genuinely required to be answered by the electricity licensees. On the last occasion, I asked Mr. Bandopadhyay also the same question.
But Lordship, kindly appreciate the situation.
I am appreciating, that is why I am asking
There
you
is
the
a
question.
non-obstinate clause, Lordship. Whatever is
Non-obstante
there.
clause, the non-obstante clause can be interpreted in several ways.
Yes.
Very well.
And
but
your
that
Lordship
does
has
not-
fallen.
That does not, Mr. Dr. Sahara, no point arguing. You have to answer the court. The court's query is, what steps have you taken as regards the defaulters?
But so far the defaulter is concerned, we could not trace from them.
Where is that document to show that?
The,
you
how
took
can I,
these steps?
how can I show that if they, suppose I have got the electric connection, kindly appreciate. I
You filed a report. Show me where in the report have you said that you wanted to take steps, the persons became untraceable.
But so far the report is concerned,
Yes.
this is stick to this point as per the regulation is
You
concerned.
say
This
what
has
steps you
fallen
take.
from your
You
Lordship
file an
right
affidavit-
now.
You file an affidavit saying what steps you took against the defaulters.
But suppose I haven't taken any steps.
You haven't
kindly
taken any steps, then
consider
you
I have
cannot-
taken, kindly record that I haven't
argument.
taken any steps.
Very well.
I have taken any
Very
steps.
well.
Lordship, kindly consider.
Very well.
Kindly
I will record
consider.
this if you are so
No, I
adamant,
am not
will record.
recording. Lordship,
Just now said.
no, I have not said that. Lordship, kindly don't take me amiss for a
You
moment.
just now said kindly record.
Lordship,
you have
don't
taken any
don't
steps.
take me amiss for a moment.
Just now said.
No, I am saying kindly allow me for a moment. Lordship,
I have
kindly-
allowed you. You are not answering the court's query. You want me to record that you did not
Then I
take
have to
any
take
steps.
instruction on this
So
issue.
say that.
Then I have to take instruction on that.
You file an affidavit.
But the
electricity
law is very
licensee-
well set.
Okay, new motion. Yeah.
I'm not am for the petition, man. All I have received.
Yes.
Well, there's an order of the DM, my lord, for my lord shifting my lord the pole which was my lord inside my premise. My lord, and after that, my lord, kindly sees my lord page number 24, my lord. They've scheduled a program, my lord, for shifting of that said pole. My lord, page 22, my lord, is the order and must
Who is appearing for the licensee?
no one is there. My lord, copy has been served, my lord. I can, my lord,
Lord, I have the instruction, my lord. We have not received any, my lord, copy of the writ petition, my lord. Kindly.
Madam, my lord, serve and come back.
लिखे नहीं. Then I'm making it not.
Come up with you.
Yes.
My lord, I am appealing on behalf of
They appear for the
the affidavit of service.
Is this? Yes, what is your
Oh.
case?
My case is, my lord, that the petitioners took a loan of rupees 7,09,059 from the respondent's bank, and thereafter, my lord, they have given rupees 12 lakhs to the respondents. Now, what happened, my lord? Suddenly, a notice under section 13(2) was served, under Surface Act was served upon the petitioners, but the petitioners could not give reply to that notice because they were very much sick. All the medical certificates I have annexed, my lord. Now, my humble submission is this, your honor, my lord, that if the notice under section 13(2) is not replied properly, the petitioners will not be able to defend themselves before the DRT, my lord, Deputy Recovery Tribunal. So my humble submission is this very small, my lord. Kindly give a chance to the petitioner to give reply.
How is your writ petition maintainable against a private individual? How have you come up against a private individual? Aadhar Housing Finance Limited is not a statutory organization.
That is a financial institution, Lordship, and also Lordship kindly comes to
लिखे
be
नहीं.
clear, Lordship, they have
The writ
challenged the
petitioner is
13th.
agreed.
Item number 7, Lordship, I'm for the petitioner, Lordship. Service is complete, Lordship, but affidavit of service is in the process of affirmation.
Private respondents also.
Yes, my lord.
They are all completed.
Then they are appearing.
Yes, your Lordship. Lordship,
What do you want?
electricity connection, Lordship, electric connection. I'm the tenant.
Why are
Lordship.
you not giving?
My lord, he is a tenant, my lord. He
I'm
was
the tenant.
using the electricity from the, my lord, meter connection of the landlord, my lord, for long. My lord, there is a dispute between the landlord and tenant, my lord. We have inspected, even my lord, 3rd of August, my lord, we have also inspected. My lord, an angle is to be, my lord, installed there for giving connection separately to the tenant. There are other tenants also. They are also enjoying electricity from the same meter of the landlord. But now he has applied for the connection, we can give it. But my lord, the installation of angle is required. Now my lord, the landlord has given written in objection. And he is not, my lord.
It will not create any right in his favor. A special right or equity will not be created. Give him connection.
Lordship, it was disconnected by the private respondent on 13th June.
You don't have a connection in your name.
I don't have any
You
connection.
have applied for a fresh connection.
I have applied for the fresh connection. I have paid the quotation amount as well.
They will give you a fresh connection. There is some angle which is required to be installed. The landlord will not object. At a vantage point, they will.
Much of it.
And this will not give you any equity or special right.
Yes, your Lordship.
Police protection like that.
This writ petition
I am confused.
Yes.
I am sorry if you lost. I have hurt the feeling of your lordship. My tender apology.
Yes, Mr. Halder.
I am for the petitioner. Let it be on Monday. They have already sent 45 lakhs bill. I want.
45.
আমি শুনলাম এখনো হাতে পাইনি। Let it be on Monday. I'll start. একটা order pass করে দেবে তো চিন্তা নেই। I have to take instruction on the 45 lakhs just I heard. So I have to take. Let it be on Monday. And some order be
Mr.
necessary.
Halder, learned advocate appearing for the petitioner, seeks an accommodation.
Extremely sorry, lordship.
Not a problem, not a problem. Next.
Yes, my lord, I am bringing humble submission that not today, my lord. Senior is out of state. My senior is out of state, my lord. My senior is out of state.
Okay.
Yes.
Next.
Yes, sure.
Well, item number 10, my lord, I appear for the petitioners.
Petitioner.
Service করেছেন?
Yes.
My lord, I have effected service, my lord. My lord, issue in question is, my lord, very short, my lord. My lord, I have filed the SARFACI application, section 17, before the DRT. During the pendency of the SARFACI application, my lord, there was an order passed under section 14. I challenged that. My lord, now presently what happens is, my lord, after passing of the section 14 order in light of the Shilpi Hotel's judgment, they give a notice that I'm coming after 7 days, 10 days, you vacate the property. That notice was given to me. I have annexed that copy. That notice was given to me on 22nd of July. That notice was given to me on 22nd of July. I received it on 27th of July, but I candidly admit there is no pleading to that effect. 27th of July, I get it. Immediately after 24th of July, I get it. Immediately after getting that notice, on 27th of July, I file an application impugning the section 14 order. And I am on a fundamental point in that application, NPA bad, etc., etc. According to me, my scope of challenge is correct. According to the bank, they have a good case. Nonetheless, my lord, is subject to judicial scrutiny. During the pendency of that application, my lord, matter was listed on the 30th under the heading put up before the debt recovery tribunal. On 30th, my lord, the matter could not have been taken up due to paucity of time. Accordingly, I mentioned, considering the urgency, the tribunal fixed the matter on 31st. The date of possession, taking over possession, was on 31st itself. So considering the urgency, it was again fixed on 31st. I have annexed the cause list also. On 30th, since the matter could not have been taken up by the debt recovery tribunal due to paucity of time, I wrote an email to the bank. My lord, my email is at my lord, page 93 of the writ application. My lord, primarily, my lord, if your lordship kindly sees the possession notice, my lord, which is at, my lord, page 86.
Page 86.
86 is the possession notice. Well, I'm not troubling your lordship by taking your lordship into the merits of the order. That is not the scope of my writ petition. Page 86 is the possession notice. My lord, page 86, my lord, on bare perusal, your lordship will find, my lord, that the date of taking over possession, dear ma'am, third line from that, page 86, my lord. Third line, dear ma'am, it is 31st. Third line, on or before 31st. And this notice is dated, my lord, below, my lord, right-hand side, the date is given 22/7. Same page, my lord, 86, below right-hand side, where the seal signature of the clerk in charge. So it was 22nd, I received it on 24th. Now, my lord, immediately after receiving it, my lord, the threat becomes writ large. Your lordship will kindly come to, my lord, page 89. This is my put-up petition.
Now, my lord, page 29, your lordship will see, my lord, the affirmation page is at page 91. It is filed on 27th of July. So it is not a case I delayed in approaching. Immediately I approached the debt recovery tribunal. This put up was considered and date was fixed on 30th. Now, my lord, your lordship will kindly come to page 93. Rajiv Jhunjhunwala judgment. My lord, 93, my lord, I specifically write to them that the matter was fixed. I am impugning an action under section 14. You are going to take over possession in light of the strength of section 14 order. So kindly do not dispossess me tomorrow because the judicial scrutiny is pending. Since you are taking over possession under strength of section 14 order. And I also refer to a judgment that is persuasive value of this honorable court in the case of Rajiv Jhunjhunwala. Where, my lord, only distinguishing factor in Rajiv Jhunjhunwala in my case is in Rajiv Jhunjhunwala's case, my lord, the case was being heard by the tribunal. A date was heard and a next date was fixed. In my case, a date was given. It could not have been heard for paucity of time. I referred to that case also and told them, do not dispossess me. And your lordship knows, my lord, under rule 3 of the SARFAESI rules, my lord, email service is a good service. And considering the urgency of days, my lord, I couldn't have effected any other service. I served it to them by email. And my lord, they, on 31st, after getting my email, not waiting for the judicial scrutiny, my lord, they come and they dispossess me. Now, my lord, I cannot go back to the DRT now, but I tell your lordship why. My lord, I am impugning a primary fundamental challenge that
it's amenable to DRT. You can go to DRT, get your possession back.
My lord, with deepest of, my lord, with deepest of respect, my lord, only one thing your lordship considers, my lord. I know this is my
I'll say DRT will consider it with utmost expedition. When is the next date fixed before
20th August?
20th August.
20th August.
You have already been dispossessed.
But only
approach. I'll say on 20th August.
Only one thing, my lord, only one thing. My lord, your lordship knows, my lord, under section 17(3), my lord, rightly or wrongly, my lord, I am before an equitable court, my lord.
Equitable court. Now there are several judgments. You know it better. You have been dealing with it for so long. It's like a total bar now.
My lord, even, my lord, oh, my lord, just 1 minute, my lord. My lord, your lordship is referring to all those PHR invent society.
Yes,
my
yes.
Lord, my lord, what is bar is, my lord, if I bypass a forum. That is
you are there before a forum. That is all the more. Now you have been dispossessed.
There are 3 SARFAESI application pending in the.
You know, you have the wherewithal to get it heard.
Well, only one thing. Only 1 minute, your lordship listens to me. Well, here, under section 17(3), my lord, of the SARFAESI Act, my remedy, my lord, I have rightly or wrongly have preferred a challenge. If the DM order would have been set aside, my lord, I wouldn't have been dispossessed.
If you have a case, you can get it set aside before the DRT. Once it is set aside, it will be restored.
It was taken up yesterday. When the DRT taken up the matter yesterday, but
that is not
adjournment.
That is not the scope of the act. Well, why I tell you, lordship?
If the DM's order is set aside, the possession can't be taken.
No, my lord.
Possession can't remain with them.
My lord, with deepest of respect.
If this adjudicated, I'll then pass an order that it can be done. Not now. I will not preempt that decision by the DRT.
My lord, kindly only fathoms one situation. Well, kindly takes up section 17(3) of the act once, my lord. Well, the scope of the act says that even if the DM order is set aside, the DRT does not have the power to restore back possession till a section 17 application is heard and adjudicated.
Then if that is the intent of the statute, then in that case, even I can't do it.
My lord, with deepest of respect, my lord, deepest of respect, my lord, your lordship, my lord, is a constitutional court, my lord.
Even constitutional court does not mean that I will bulldoze the statutory provision.
So, my lord, I am before your lordship with only one plea, my lord. My lord, your lordship will test this in the touchstone of equity, my lord.
Even then, you are before the DRT, you can get it.
My lord, I will not get back the possession before a section 17 adjudication.
Yes, 17(3). What were you reading?
My lord, 17(3), my lord, your lordship kindly sees, my lord, 17(3).
It is exactly the opposite of what you said.
No, my lord, no, my lord.
Yes.
The deepest of respect, my lord.
Yes.
To declare, my lord, if it declare any of the recourses under section 13(4) bad in the eye of law, my lord.
Thereafter?
And thereafter, my lord, restore possession of the secured asset management of other person aggrieved who has made an application under subsection 1. So subsection 1 is section 17, my lord. This refers to section 17.
Yes, so you made an application. This does not mean that the application under section 17(1) has to be, if your order 14, section 14 goes, no, mister. It will be too cryptic reading of the section. I don't have that myopic view.
My lord, section 17 application has to be disposed of, my lord.
No.
My lord, in that
is your reading.
for one.
Where is that written?
My lord, kindly see, my lord, section 13.
Yes.
Section 17(3).
Yes.
If the debt recovery tribunal, after examining the facts and circumstances of the case and evidence produced by the party, comes to the conclusion, any of the measures in subsection 4 of 13 by the
Yes,
secured creditor-
why is this so? Every action taken under section 13(4) is assailable under section 17.
Grateful, my lord.
Now, if you file an interlocutory application under section 17, you are actually required to challenge the order passed by the DM by way of a section 17 application separately, which you are not doing. You treat one section 17 application as the main applications and all other applications as interlocutory applications branching out of the section 17 application, which is why this misconception is there. Now you treat each of the interlocutory applications as an application under section 17 only. Now when the DRT adjudicates the interlocutory application, which power does the DRT invoke? It invokes its power under section 17 when it rejects the application which is interlocutory in nature, or it allows the application which is interlocutory in nature. It does so by dint of the powers under section 17 of the SURFACE Act. Therefore, every interlocutory application that the DRT will be entertaining by rejection or by allowing will be by dint of the powers under section 17. So the order passed on your interlocutory application will also be an order under section 17(3), and therefore that restoration can be done. It's not that simple.
My lord, in that event, my lord, Oasis Dealcom's judgment of the Honorable Apex Court, paragraph 23, my lord. I'm not equipped with the judgment now. My lord, the statute gives me 3 doors, my lord. Either a fresh section 17 in a fresh measure or
the power is section 17 only. The power to set aside. Where is the section 14? Going by Kanhaiya Lal standard,
my lord,
section 14 is a step under 13(4).
My lord, my lord.
Once a section 14 is set aside, is not a step under section 13(4) set
But I'm
aside.
not entitled to be restored back with the possession till my 17th principal application is not at
This principal thing is not there. This is something which you have invented and inserted in the statute. Show me where is it said that this principal application, interlocutory application, it is a power of the DRT to be exercised under section 17.
My lords,
I exercise it for setting aside a section 14 order, or for setting aside a possession notice, or for setting aside a physical possession order under section 14, or bank taking physical possession directly under section 13(4) without invoking section 14. All these are steps under section 13(4). The moment the DRT adjudicates an interlocutory application and sets aside that, it exercises power under section 17.
My lord, with deepest of respect, my lord. My lord, the statute opens 3 doors for me. Clearly stated in the judgment of Oasis Dealcom by the Apex Court. One, my lord, if I file a section 17 being aggrieved by a 13(4), which is a measure, it is pending. Thereafter, bank goes for sale under Rule 86 or possession under section 14. I am, in terms of the statute, permitted with 3 recourses. One, file a separate section 17. Number 2, file an amendment to a section 17. And number 3, file an interlocutory application.
Now, all of these 3 actually translate into invoking the DRT's power under section 17 only, because the DRT does not have any other power under the 4 corners of the 2002 Act to set aside a section 13(4) action.
My lord, I bow down before your lordship. Only one impediment, my lord. My lord, fathoms the situation. In my case, my lord, I filed a section 17 including a 13(4) measure. I'm permitted to do that. In the interregnum, my lord, a subsequent measure has been taken by the secured creditor by filing a section 14. I am before your lordship. I have filed an interlocutory application. Under the statute, I am permitted to do that, my lord. Now, my lord, kindly reads 13(3), 13(3)(b) in light of that.
If I go by this logic of yours, and if that is the intent of the legislature, then even the High Court will not be able to do it. You read Glaxo. For example, if there is a provision which says that only up till this, for a period of 6 months from the starting of cause of action and no more, a petition will be entertained throwing challenge to a particular action. Can the High Court, in exercise of its writ jurisdiction, enlarge that power? That has been negated by the Honorable Supreme Court, saying you cannot do it because that is the statute. Article 226 is not meant to bulldoze statutory provisions, to set your own standard that no, I am Article 226, therefore I am superior to everybody. No matter what the statute says, I will do it. That is not what the Article 226 remedy is supposed to do.
Your lordship is also an equitable jurisdiction.
Very well, equitable. That is why your remedy lies before the DRT Go and get that adjudication done. If the DRT negates your claim, then in that case you have your remedies available. It's
Well,
not
my
that you are
remedy is
remediless.
again- My remedy is again under section
That
18.
is your misreading of section 17.
Well, may I come back with a judgment? May I come
For
back
what?
with a judgment?
You
Only
will
on
be-
this.
You will
pretext,
be unnecessarily expanding it. You want to come back, you can come back. When do you want to come back? Tell me. Unnecessarily, your DRT proceeding will also remain, and you will also remain out of possession till such time that you get this adjudicated here.
My lord, I bow down. My lord, in that event, my lord, only one thing, my lord, your lordship, can he directs the DRT?
Yes, that's what I was exactly
Great.
going to do.
Great.
Likhen. This writ petition
May I please your lordship? Not my affidavit of service.
I appear for respondent number 2 and 3, madam. Okay. This is a asset reconstruction company, madam, not a non-banking finance company.
Oh, so
So the
therefore the
notification,
regulation will not apply.
no, my lord. That is my contention, my lord. I can place the notification in
Yes,
correspondence
please,
with the.
please do so. Please do so, so that I can also understand.
Yes.
Because that day it was hurried appraisal. Yes.
Yes, my lord. Kindly come to the notification, my lord. It's at page 40.
May I have a copy of the notification?
You have, this is your writ petitions.
Which notification?
Notification which you are relying upon.
Page 34.
34, my lord. Yes, my lord. May I just read it? I copy it from. Yes.
Case 36.
In
Case
my-
34 is the parent one.
Yes, yes,
36 is the amendment.
Yes, subsequent
36
one.
is
my
the
lord.
amendment,
Yes,
yes.
my lord,
36 only changes the figures.
Figures.
From 50,000 to 20, yes.
Yes, my lord. My lord, may I read the notification, my lord? In exercise of powers conferred by subclause 4 of clause M of subsection 1 of section 2 of Securitization and Reconstruction Act, my lord.
These two entities are separately defined in the SARFAESI Act.
Yes, my lord. And it has to be read in correspondence with 45I, my lord.
45I.
I of the Reserve Bank of India Act, my lord.
Yes.
Now, financial institution under SARFAESI Act includes both the asset reconstruction company as well as the non-banking finance company, my lord.
Yes.
Had it been intent of the legislature to include asset reconstruction company also as a non-banking finance company, my lord, there was no requirement to keep it under separate heads, my lord. Moreover, the registration.
No, but under SARFAESI Act, financial institution includes both.
Yes, my lord. Yes.
2M includes both.
Yes, my lord.
Then if this notification pertains to SARFAESI Act, why will it not include the asset reconstruction?
Because it is specifically, it applies to the non-banking financial companies, my
defined
lord.
in clause F.
Yes.
So yours does not fall under clause F. And in the RBI Act, asset reconstruction company has been defined separately.
Yes, my lord. Even in SARFAESI Act, the process of registration is different, my lord. It's non-banking finance company and
Do you have
SARFAESI.
the RBI Act?
Yes, my lord.
Please show me that.
Yes.
Because that is the most relevant thing.
I.
45
IF, my lord. I have.
IF.
Yes.
Ms. Soja, there is something wrong with the book, I think. There are a few pages.
I flag mark that page 45I.
IF.
Yes. 45I subclause F, my lord. The Reserve Bank
yes.
of India. Yes.
Non-banking financial institution company means financial institution, non-banking institution, such other non-banking institution. Oh, yes.
So
it is this notification will apply to financial institutions under section 2M4
yes, my lord.
of the
And the
SARFAESI Act.
Yes, my lord. And the judgment relied upon by my learned friend does not apply here, my lord, because in that judgment, my lord, Piramal Housing Finance Company was the party, my lord. So my contention, I appeared in that matter also, my lord. So my contention was that Housing Finance Company.
That matter, Federal Bank was not cited.
My lord.
Federal Bank was not cited.
My lord, cited, but since the notification was under challenge, my lord, so that's why the point of maintainability was not entertained, my lord.
But notification has not been set aside. Notification has been upheld.
Yes, my lord. So pursuant in that matter was also carried into appeal, my lord. There also the order was affirmed. However, it was clarified, my lord. The honorable single bench as well as the division bench, my lord, relied upon the subsequent notification of 2023, my lord, where the NBFCs were categorized under 4 separate categories: upper layer, middle layer, lower layer, and the last one, my lord. And Piramal Housing Finance Company was specifically included in the middle layer of the NBFCs, my lord. That's why it was held, my lord, that housing finance companies also comes within the purview of non-banking finance company. Here, this is a totally separate case, my lord.
Yes,
This
madam.
is asset
Then
reconstruction
the
company.
notification itself
had
does not
to be
apply to you.
Judgment of the division bench, my lord. The relevant paragraph 21, my lord, can peruse, my lord. If my lord have a look. Subsequent notification of October 19, 2023 was relied upon by the both the single bench as well as the honorable division bench, my lord.
Which paragraph? Which paragraph are
So
you?
I'm relying upon the division bench order. Do you have
This one, right?
FME? Yes, para 21.
Which paragraph you said?
21, my lord.
21.
Yes.
2022 circular.
Yes, my lord. And also 2023, sir.
2023. Where?
Yes.
Where is that referred?
Lord, kindly come to paragraph 21 and subsequent paragraph is my lord 2022. 26 also is the relevant paragraph, my lord, where it has been observed that the honorable single bench relied upon the amendment of August of October 19.
In any case, this is not relevant here because yours is not a housing finance.
Yes, my lord.
Yours
So that's
will
why-
be governed strictly by 2M4.
Yes, that is what. Just to clarify, I place this judgment, my lord.
Yes,
My
madam.
lord, I was relying on section 5 of the Act, of the 2002 Act.
Yes.
Lord, if I may read out subsection 2.
Section 5.
Yes, section 5. If I may read out the entire section, my lord. Notwithstanding anything contained in any agreement or any other law for the time being in force, any asset reconstruction company may acquire financial assets of any bank or financial institution by issuing a debenture or bond or any other security in the nature of the debenture for consideration agreed upon between such company and the bank or financial institution, incorporating therein such terms and conditions as may be agreed upon between them, or by entering into an agreement with such bank or financial institution for the transfer of such financial assets to such company on such terms and conditions as may be agreed upon between them. 1A. Any document executed by any bank or financial institution under subsection 1 in favor of the asset reconstruction company acquiring financial assets for the purpose of asset reconstruction or securitization shall be exempted from stamp duty in accordance with the provisions of section 8F of Indian Stamp Act, provided that the provisions of this subsection shall not apply where the acquisition of the financial assets by the asset reconstruction company is for the purpose other than asset reconstruction or securitization. My lord, kindly note the proviso as well. I am reading it again for your lordship.
Yes, I've read it. I've read it. This is for the purpose of acquisition of financial assets. How is it relevant here?
Other than asset reconstruction or securitization.
Yes.
So thereafter, if the bank or financial institution is a lender in relation to
Yes,
any
but how is
financial
this
asset.
relevant, madam? It's a big section.
My lord, my point is whenever an asset reconstruction company is taking over a financial asset of a NBFC, it is stepping into the shoes of that NBFC, my lord.
this is just the power. This section just recognizes the authority of the asset reconstruction company to take over the asset of the financial asset of the NBFC.
Yes,
It
my
does
lord.
not, by this reason, ipso facto, turn it into a non-banking financial company
My lord, it
within
does
the
not
meaning
turn,
of
but whenever
this
it
provision
steps,
of RBI Act.
my lord, my lord, whenever any principal, if I go by that concept, a principal's power cannot, agent's power cannot go beyond the power of the principal, my
This
lord.
is not the
My
agent's
lord,
power.
if an
ARC will have its own power. Asset reconstruction company will have its
My lord,
own power.
however,
The
it cannot go
question is whether this
beyond the power
notification-
of NBFC, my lord.
Madam, this notification of RBI by which the threshold limit for the purpose of triggering jurisdiction to issue a notice under section 13 of the SURFACE Act
Yes, my lord.
will apply only to those non-banking financial companies which are defined as such under clause F of section 45I of the RBI Act.
Yes, my lord.
Now, clause F of 45I of RBI Act does not include within its fold asset reconstruction companies. Therefore, this notification goes out of the scope, and the asset reconstruction company does not fall within the domain of this notification.
My lord, in that way, the intent of the legislation will be at that point of time.
No,
My lord, any
for example, it can't. Intent is only to
limit the claim amount.
Only to curb the powers of NBFCs. It is not the intent of the RBI or the ministry to curb the power of either asset reconstruction companies or other banks. Because if that had been, then in that case, this classification would not have been there. This
My lord-
express mention of clause F of section 45I must be given some meaning.
My lord,
The
then
meaning
kindly
is
appreciate,
the
my lord, that
definition.
in that way, to every NBFC will transfer their claim below the 20 lakhs
Can
limit
they
to
will.
any ARC.
They can,
And
they will.
then,
There has
my lord,
to
in
be-
that way, that every ARC will get that power of claiming below 20 lakhs under the SURFACE
That is
Act, my
not the
lord.
scope of the petition also. In any case, since the notification does not apply, there can't be any
My lord,
stay.
whenever any ARC is stepping into the shoes of NBFC, it cannot go beyond the
ARC
powers
is not
that.
stepping into the shoes of the NBFC. ARC is only acquiring the financial asset. It is not that the ARC by itself cannot issue section. ARC's business only is to take financial assets in.
My
That
lord,
is
but
asset
not under
reconstruction.
SURFACE Act, my lord,
Go
where
by the name of the entity. It is asset reconstruction. It takes hold of that such assets which are sinking, and then it tries to reconstruct them. That is their business.
my lord, but it is below 20 lakhs, my lord. My lord, kindly appreciate that when
The notification has to apply. It doesn't apply. We cannot extend it by way of our
My
interpretation.
lord,
we cannot.
then I shall rely on certain judgments where that ARC is also whenever it is stepping into the shoes of NBFC, it cannot go beyond that, my lord.
Come tomorrow, if you want to rely. I will not stretch it for long because I don't think that it needs that.
My lord,
Till
kindly
when is
gives
the-
me a week's time so that I can.
I will not extend the stay anymore.
My lord, then keeps it on Friday, my lord, because there is 1 week of interim order that I'm enjoying, my lord.
No, Friday will be too dicey. You keep it
But
tomorrow.
I have to go through a lot of judgments
Go
to.
through it tomorrow tonight and come tomorrow. And next.
Pursuant to your lordship last order, my lord, I have served notice upon the.
I wait for Passover, Lordship. Kindly take it up 2 p.m. And Mr. Shah is appearing in this matter when he is arguing court number 12.
Not today then.
My lord, may I retain this or I'll hand it over?
Lord, I'm for the
tomorrow.
respondent number 4. Appearing, my lord, in the I'm respondent number 4 in this.
Very well, tomorrow.
Tomorrow, my
So next.
Yes.
Lord, not a very happily drafted application, but I tell you, Lordship, not application for restoration and substitution together. Now, take can 2. Lord, I tell you, Lordship, what is the writ petition about? The writ petition was filed, Lord, in 2000, 2001, government came up with a scheme for allotment of vested lands, my lord, in the district of South 25 Pargana. I am a hotelier, my lord, in that area. I applied under the scheme. Now nothing could be done. The affidavit in opposition reply is completed in the writ petition.
But how do I have jurisdiction for this? I don't have jurisdiction for this. Let this
But
matter go out of
for
this.
hearing
Then you serve and come then. After so long, suddenly it has appeared, serve and come, serve the state and come. Serve the state and come. The petitioner shall serve a copy.
I appear for the fees.
Lord, I am for the response.
Can 2 is the restoration application.
Beginning. In view of the
Can one? No.
affidavit of service লিখে দিন।
সে তো তোমার রিট পিটিশনে আছে।
Next.
Well, the application should be served, my lord. I have not.
Serve a copy লিখে দিন তো।
I have written the copy of the
Closing this application.
Yes. I am I am filing the affidavit of
But at the very outset, my lord, may I indicate, my lord,
there have been unnecessary allegations put in this application. Lord, I need to use an affidavit. If your lordship wants me to.
Why? What is the matter? If it can be
Lord,
done, it can be done.
his petition, Lord.
Yes, Mr.
Yes,
Chakravarti.
my lord. This petition has been filed by my client, my lord, for recalling of the order dated 18th of March 2026, which has been passed ex parte, and the direction given by your lordship to serve copy within the specified time, that has also not been followed. Long thereafter, we have been served with the copy. And on service, we came to know about the facts of about the instant matter, my lord. My lord, the petition has been projected as we usually face, that in case of eviction suit, deposit is made in the name of the landlord, and landlord will withdraw, and objection of the defendant is immaterial. This is the normal thing, naturally goes on, my lord. But this case is something otherwise. My lord, why otherwise I am saying that I have got an industry at the suit building, and the industry gets used to get electric supply from a high tension line in the name of the previous landlord, and that now upon under the present landlord, who stepped into the shoes of the previous landlord, because the father and some other persons were previous director. Now there has been a change of director, and my evidence has been is going on. Be that as it may, my lord, my line has been disconnected. That's why I am unable to carry business, though I am regularly going on making deposit of payment of rent. I was going. My lord, thereafter suit filed for eviction. In the eviction suit, my lord, I filed a written statement with counter claim. In the counter claim, I have paid for a sum of rupees 3 crores on account of, my lord, compensation, and which I have suffered due to the act of the plaintiff, my lord. Now, 7-2 matter was disposed of initially by the trial court, and a direction was given by the initial order. The director's direction was given by the trial court to deposit to pay the rent to the landlord. Against that, we came in revision. The matter was heard. There has been some dispute regarding the amount. There has been dispute. The initial matter was heard by Honorable Justice Standon, and considering the controversy between the parties, the Honorable Court directed the defendant to deposit the amount in court in connection with the suit. My lord, thereafter, my lord, regarding my lord, rate of interest or amount of interest, at least 4 to 5 times, either we came or the plaintiff came. That order I have annexed. From those orders, all such orders, your lordship will find that on every date, every occasion, order was passed to deposit the rent in court.
What I have done, I have asked him to withdraw. I have not directed to withdraw.
My lord, that your lordship's order has influenced the trial court to pass the order. My lord, let me end. Let me complete my.
No, if I can understand, then I can immediately.
No, my lord, my case is that entire facts has not been placed. My lord, kindly see that. That is I am saying, my lord. Thereafter, my lord, this was going on. Then the plaintiff, my lord, actually, besides that, plaintiff filed suit in the capacity of
Mr. Chakravarti, just to expedite the thing,
yes.
If you answer the query, I think it will be easier for us to understand.
Yes.
Instead of going into the entire history.
Yes.
Is there any order by which the plaintiff's was allowed to withdraw?
Yes, my lord.
That order has been set aside by the court. We have challenged it.
After order being passed by your lordship, my lord, during pendency of this application for recalling, they my lord pressed the application, pressed before the court that there is no stay order. So on basis of that and
No. There is an order permitting them to withdraw. That was
withdraw.
what was shown.
Yes.
Now that order has been challenged by you anywhere.
No, my lord, that has not been challenged because that order, my lord, very recently we came to know because we made the submission before the court below that we had already filed application for recalling. Copy of the recalling application was also served upon the learned advocate of the lower court.
But the order is not yet recalled.
No, order was not been recalled. But I have not prayed for recall before that court because recalling in the High Court's order cannot be recalled by the.
Not this order.
Yes.
This order does not permit him to withdraw.
Yes.
This order is limited.
Well, we have filed an application for my lord, in a date when the Howrah Bar Association declared not to attend. In that case, in that date, they obtain an order for withdrawal. Immediately on coming to know about the said fact, we file an application for my lord not to allow the withdrawal and to hear out. On basis of our application, the court held that yes, recalling application is requires to be heard. But those facts have not been placed.
Mr. Kormokar,
Please,
may I be precise?
Though, my lord, let him place here the application.
Chakravarti, 1 minute.
None of the documents.
1 minute, Mr. Chakravarti. Mr. Kormokar, if there is an application seeking
In the court below, we have filed application.
Seeking stay on the withdrawal.
There is no application.
He says that he has filed an application.
No, we have
completely something different from the records is being told to your lordship.
No, we have filed application for. We have filed application for recalling of the order by which the.
Let my learned senior friend conclude. I'll then
show me that order by
Yes.
which it has been
Yes.
recalled or anything has been done.
Yes, my lord,
Because
kindly
that is
see.
the matter. If there is an order withdrawing it, then in that case, this order will not stand. This has to be recalled.
My lord, kindly see. Record. My lord, your lordship kindly. My lord, kindly see page 49 and 50.
Page 49.
Yes.
Yes.
Corona. Page 49, my lord, kindly see. No, no, ठीक.
49, yes.
Yes.
51.
ঠিক আছে আরে ঠিক আছে পেজ 49 মানে today is fixed for PH none taking any steps due to resolution of the local bar. The case is adjourned being 11/7/2024 for PH. My lord, next order. Sole plaintiff Sri Chandrapoka Jhanjunwala on the same date, my lord.
Yes.
Sole plaintiff Sri Chandrapoka Jhanjunwala files a petition duly supported on the affidavit praying for passing payment order of the entire money deposit. Learned advocate for the plaintiff files some searching from the accounts department for the month of June 2015, July 15. These searching are verified. Copy of the challans are found from the month of copy heard the submission of the learned advocate for the plaintiff. Let the payment order be passed. This is the order, my lord. Thereafter, my lord, immediately we file application my lord, next page, page 52.
Yes.
52, my lord, we written objection we have given after the order was passed, my lord.
Right. What happened thereafter?
Thereafter, my lord, court hold that this objection is to be heard.
Yes, that very.
Thereafter, my lord, at this stage, my lord, no order was passed in connection with our written that of.
Yes, Mr. Kormokar, why should this objection not be considered then?
Lord, kindly comes to, your lordship has the revisional application to the lordship.
Yes, I have.
Yes, Lord, kindly takes my revisional application. Lord,
Yes.
what was the issue?
And my
with
lord,
your
kindly see your lordship order, my lord, kindly see that has not been followed. Your lordship passed an order.
Mr. Kormokar, it was not the intention of the court that if there is any pending objection that has to be overruled or bulldozed.
Lord, payment order was issued. Thereafter, subsequent directions were passed to the department. Why I came to your lordship? I came to your lordship because the department
Yes, but
was dilly-dallying.
this order should not be meant to read that you have to be paid despite the objections being there and
The
not being
objection has been
decided.
heard out. The
Objection has been decided.
I'll take your lordship. Kindly takes the revisional
My
application.
lord, there are kindly see the page
Let my lord see the
page
page
71, my lord.
Page
Kindly see.
71.
Yes.
Yes, page 71.
Today is fixed for cross-examination of PW1 on recall. Submission both the parties defendant file statement of area rent and interest deposit by the defendant as per judgment. The defendant file written objection to the application for the plaintiff for withdrawal of the rent and interest deposited by the defendant court. As such, order is required to be recalled.
Yes, Mr. Kormokar.
My lord, this has not been mentioned.
If this was placed, I would not have passed this order. This is not.
Lord, kindly comes to.
Let my friend, my lord,
Civil revisional
produce
application.
his.
I understand my learned senior
My lord.
has concluded.
My lord, let my learned friend produce his
But I
application.
understand my learned
My
senior.
lord, where he has stated those
Very
things and where
Lord,
those
kindly-
documents have been stated.
Lord, I have annexed the entire order sheet.
Yes, yes, very well. But
Lord, kindly
the
comes
order
to my
sheets,
revisional
I may not
application.
have gone.
Lord, kindly comes to the revisional application.
Yes. Mr. Kormokar, this revisional application was disposed of ex parte on the understanding that this is innocent order. It is
Yes.
not going to suffer. It is not going
Yes.
to make anybody suffer.
Yes.
But as it appears from this order dated 21st of April 2025, if the order which forms the basis of your withdrawal itself,
Lord, my
has
lord
been
is my lord is looking into Lord.
page 71, which is just now showed.
21st of April 2025.
Yes.
Very.
Read the 1, 2, 3. Read the fourth paragraph.
Yes. Lord, I have annexed that. I have annexed that.
You
It
may
was
have
placed.
annexed this, but this
Lord,
has
it was
to be
placed also. I'll take
if
your
it,
lordship.
if it
Lord,
was placed, I am not so idiot, Mr. Kormokar,
Can
that
I
even
even
if this is
think of
placed,
saying all these things?
then if this was placed, I will pass
Kindly,
this on.
Lord, thereafter turns over.
Sir, objection pending and not.
Your lordship has the revisional application.
Yes, I have it.
Lord, kindly comes to the order dated 21st of April 2025.
Yes.
Lord, why I came to your lordship? The reason was this 21st, Lord, just 12th June 2024 order of compliance that was not being complied with by the department.
Because 12 June 2024 order is recalled. How can that be complied with now? 71
Lord,
is exactly that.
Lord, what was recalled? I'll just indicate. As such, the order is required to be recalled for the
Yes,
purpose
the
of
entire
hearing
order
the
was
petition on the
recalled.
point of objection.
Yes,
On
the
the
entire
point of
order was
objection.
recalled.
Now, Lord, what your lordship had passed?
Mr. Kormokar, this order needs to be recalled because this 12th of June 2024, you get it heard now on notice to them. They are there. I am recalling this order because
Yes.
this.
Lord, kindly sees what order your lordship has passed.
I have understood whatever order, but this order I have not taken into consideration when I passed this order.
No, but what order your lordship has passed? Your lordship has not somewhere prejudiced their rights. No way your lordship has prejudiced. Your lordship has not directed to pay.
I have taken into consideration 12th June 2024 order only.
And January 15, 2025.
Yes, but this is subsequent to January 15. This is
in view of the nature of the order proposed to
yes,
be
that I
passed
understand.
prior to the
But
service
then
of such and such.
This order has the basis of the order again is June 12, 2024
Your
order.
lordship has not for a second said not pay it to me. Your lordship wanted the department to ascertain, clarify, and then if I am entitled to release the payment. That's exactly what your lordship has done.
That also, I have not said that to release the payment. I have said that whatever information was sought, that should be given.
Absolutely.
But then whether the information sought should at all be provided or not, that also seems to not be there because of 12 June 2020.
Not information sought to be provided. That's exactly what I'm showing to you, Lord, what had happened. Lord, kindly comes to Lord, the repeated orders.
Repeated orders. Yes, you showed repeated orders on that day only.
Lord, thereafter, all these defendant
This order
tender
was,
challans, tender
Mr.
challans.
Kormokar, Mr. Kormokar, if the order itself is recalled, how can you seek a direction on the basis of that order again?
Lord, I came up before your lordship, Lord, that this particular payment
You
order
have
was
come
being
up-
stalled,
you have
not
come
being
up-
heard.
Mr. Kormokar, your prayer was in compliance with the order dated June 12, 2024. That was your
Yes,
prayer.
yes.
Now this order has been recalled.
No, this order had been recalled.
Yes,
This order had been
your
recalled.
prayer,
It was
then
pending.
your prayer could not have been made.
No,
This
it
prayer
was
could not have
pending.
been made.
It was pending adjudication, and I came before your lordship, Lord, so that the adjudication takes place and I get the money.
That was not your prayer. You did not seek for expeditious disposal of the application for the application which was pending or their objection. You want show cause why the order dated such and such will not be complied with. That was your prayer, and this was the understanding. Mr. Kormokar, it was never said that you want expeditious disposal of that. Prayers for expeditious disposal are differently couched. Look at your prayer at page 11.
Very well. Lord, in that case, Lord, may I just pray for only one thing? Lord, kindly fixes a date for hearing of this objection before the trial court within a
I don't have
specified time.
jurisdiction now. I will have to simply recall it. The CO will have to go before the bench having determination. I will have to recall it because of this. I can't pass any order on the main CO. Only the recalling is there. I have jurisdiction either only to recall the order or not to recall the order. But I am convinced I should recall.
Lord, takes it up tomorrow, my Lord, may come back tomorrow.
After this, Mr. Kormokar, there is
come back
nothing.
tomorrow.
Yes, sir. 16, my lord, I am appearing for the petitioner.
Lord, I am for the WBSCTC.
My lord, kindly comes to page number 54, my lord. It is my application seeking new service connection, my lord. It has not been considered and given electricity to me since the month of January. What happened, my lord? Petitioner is the gold merchant running his gold jewelry shop in the licensed premises, and private respondents are the owner of that premises. Now, my lord, there is the dispute between the petitioner and the private respondent regarding the license or the tenancy, my lord. That is why the suit is pending, filed by the petitioner for declaration of my license, and the injunction has been granted to me, and I am doing my business over there. And also, my lord, he was disturbing my position. That is why, my lord, the Honorable High Court has given me the police protection that has been communicated to the local police station, my lord, and also the Learned Civil Court has given me the police protection, my lord, by 151 application being moved by me. Hence, my lord, when the private respondents were restrained from disturbing my position, he did what in the month of December, my lord, he cut the electricity supply, and my lord, upon request to the WBSCTCL, that was not reconnected. That is why, my lord, in page number 54, I have made the application, but it is the specific contention of the station manager, my lord, that there has to be the NOC of the owner. Whereas, my lord, I cannot get that, and I am the established occupier of the premises.
Why NOC required?
No, my lord, not NOC. He has failed to produce any valid documents. We say that whether you have tenant, kindly see the kindly produce the tenancy receipt.
Something to show that you are in
Yes.
possession.
Yes, my lord.
Otherwise,
That
my lord.
I am submitting, my lord. I have the Bureau of Indian Standards document, my trade license, my MSME certificate, all for that.
Whatever you have, you submit if they find that.
Yes,
that
yes.
is
I have
sufficient.
already submitted those things, my lord.
No, already submitted
no.
will not do.
My lord,
What have you submitted?
already submitted. Yes, yes.
What have you submitted?
My lord, already submitted page number 59.
Actually, my lord, his tenancy agreement was lapsed.
59, this is, the station manager refused to take it from me. That is why it was dispatched by post, my lord. I will again
But
serve, my
what
lord.
are the documents I do? This is that is not
My
there
lord,
before
documents,
the
my lord, I have
court.
annexed here. My lord, kindly come to page number 38, my lord.
Is 38.
Kindly produce, you get a connection, no problem.
Page number 38, my lord, my trade license, Sukhendu Mal. It is the proprietor of New Sonar Bangla Jewelers, and the holding number 102 Jagatpur Bazar. This is my license premises, my lord. Kindly turns to the next page, my lord. It is my Uddam registration certificate.
Application এর পরে এটা না আগে?
All these documents are the valid documents of my possession, my lord.
Yes, Mr. Kole, if these documents are not
Yes,
sufficient.
my lord. Then, my lord, certainly, if he has possessed documents, my lord, we have no difficulty because the petitioner is raising objections saying that he has no.
What is your objection?
License already given, license already has been over, my lord.
License has been?
Already over. Currently come to page number 20, my lord.
Actually, his agreement was, my lord, lapsed on 2021. That's the
33
difficulty.
months. There is a specific provision.
Yes, that agreement may have lapsed, but he's in still settled possession. You have not been able to evict him.
Yes, yes.
The agreement.
I'm not going to evict him. My lord,
If you are not going to evict him and he's in possession, then he's in settled possession because he entered into possession
Then he's
on the basis of an agreement. The agreement may have lapsed. For him, for you to be able to get rid of him, you have to file a suit for his eviction. Till such time that the suit is decreed, he is in possession. If he is in possession, he should get electricity there. I will observe that it will not create any equity special right.
My lord, page 31 injunction order, my lord.
Injunction order in whose suit?
My favor. To restraining him to not evict me or
that also shows he's in possession. If there is a restraint order on you from dispossessing him,
order, my lord.
yes, whatever
Someone has been delivered, my lord.
prima facie he is in possession. He has documents in possession. Electricity don't oppose. You, I will observe that it will not create any special right or equity in his favor.
As your lord.
Grateful.
This writ petition alleges inaction
The appearing, my lord, in terms of your lordship's last order, well, the company winding up proceedings have been permanently stayed. Now, my lord, it is at this stage, my lord, the matter has been pending and there's a stay of winding up to the extent that the matter has been adjourned sine die. Now, my lord, your lordship was.
What is this application that is appearing?
The main company petition.
CA1 of 1994.
CA1 was, my lord, an application filed earlier in 94 with regards to revival of the company.
That is the application that is showing in the list.
But there's the CP is also appearing, my lord.
Yes.
But the CP has been permanently stayed.
Yes. Then
So,
why
my
is
lord,
it appearing?
my lord, it is appearing because it was stayed under 466 scheme, and my lord, it was adjourned sine die with the stay. But my lord, there was an operation of an order for a year where I was injuncted from dealing with the immovable property. That period has also lapsed. Now we are facing a predicament where, my lord, I cannot revive the company entirely because the official liquidators' records have to be transmitted to the MCA for the company to be now shown.
Why don't you take out an application in
Look, the order already provides for it, my lord. Lord shall kindly seize the order of Justice Bhattacharya of 28th of February 2025. I'll just place the same. My lord, page 5, my lord. Lordship, if my lord, page 5, the third paragraph. Lordship, kindly see. The third paragraph.
Yes.
My lord, the paragraph starts as if there is any hindrance. That's the third paragraph, my lord.
That is for you to approach and get police
Yes.
assistance.
And my lord, the CP was kept pending.
Yes,
My lord,
but
to the
there is-
extent of, my lord, that the permanent stay has to be
There
recorded.
is no direction that on the basis of this order you can get the records transferred to the
No.
MCA.
That direction is
File
not there.
an application if you want that. Because
We'll do that, my
on-
lord. The
on
permanent
what
stay.
basis will I pass this order?
Very
There
well.
has to be an application on record on the
Because
basis.
there's a report to that effect of the
Very well,
official.
but then your application, it's your prayer. So
Yes,
on,
sir, it is my prayer.
yes, on your prayer, I will be granting only if that is in writing. Let it come on writing in court.
I understand, my lord.
It is on the part of the ROC to make the company
Yes,
active.
but
So
but
they
no.
If they want,
My lord, there's one more thing, my lord.
I
Lordship,
direct the ROC then in that case to appear, but there has to be an application to that effect
We'll do that,
for me to assume jurisdiction.
we'll do that. We'll do that. And your lordship had asked me to, my lord, bring any order which shows that if there's adjournment sine die, it's permanently stayed and then it's adjourned. Lordship, kindly see this order, the directions on the second page, my lord.
Yes.
My lord, paragraph 6 and 7 of the directions.
Yes, so these mean different things. Adjourn sine die till such time that the advertisement and all the process which was
The payment is
indicated
made.
earlier, yes. If the payment is not made, then in that
Then
case,
it will revive.
the process, yes.
So here, my lord, it's been adjourned sine die and it's been stayed for possession of the property has been given to us
So you
till
make-
disposal.
You make an application for me to produce all this on the
Very
order.
well, my lord. I'll do that. I'll
Without
plead
an
the necessary
application on
pleadings.
oral thing, it won't be proper.
Very well, my lord. We'll do that. We'll do that.
Mr. Ghosh, learned advocate, appearing for the petitioner.
My lord, actually, my learned advocate Anupam Das Adhikari is not physically well. May kindly keep the matter in the next week, my lord. Item number 2 and 3, my lord.
लिखे नहीं the official liquidator.
Would one appear for the petitioner, Manoj? Last occasion when the matter was taken up, the respondents appeared and the matter came up suddenly. Now liberty was given to us to file a reply. We have served them with a copy of the reply and this is the copy of the reply that I am filing. You know, the company is not appearing. It's a old winding up petition. It traveled to Supreme Court and there's an order of Supreme Court.
Mr. Mitro, should this court still retain jurisdiction on this, or also all of this should go to the NCLT?
No, this should retain jurisdiction because this is after winding up. Is not the winding up happened, but payments were made in terms of the winding up. There's nothing, no list pending practically so far as the company is concerned to go to NCLT.
No, but what is the law? Is it not that unless anything irreversible has been
I'll tell
done,
you, what happened. I filed the winding. I filed the winding up. The company agreed for just an equitable ground. When I filed it, the company agreed they will purchase my shares. It agreed. Then matter went to division bench. Valuation of the shares were done. Matter went to Supreme Court and my shares were purchased. He paid me the money. So that is over. Now during this process of this 10 years, when the company agreed in 2003, he will purchase my shares. Then the company preferred to the Supreme Court and 10 years gone. Now in Supreme Court, I said that what is my loss of interest or restitution of loss of these 10 years? You only purchase the shares of the value. Supreme Court granted me that liberty that you go back to the company court and agitate this. So the price of the shares has been given to me. It is only personal liberty of the Supreme Court, right of restitution, 144 Civil Procedure Code and other rights, that I am back here. So that is the only issue to be adjudicated here.
Interest portion.
Interest or restitution? Yes.
Restitution?
Yes. Has to be. Yes. Basically, the end of that basically is interest.
It's in the nature of that only.
Exactly. So that is the only component which is pending over here.
এখানে affidavit in opposition file আছে, only reply.
Yes. Opposition আমার কাছে তো আছে। না opposition has been served on us. Whether it's filed or not, that
it's not there on the in the court record.
না operator জজ সাহেবের কাছে affirm copy লাগবে তো। তোমার কপি দিলে হবে কি করে? We have a copy
appearing for the company.
No, এই তো ইমন ভট্টাচার্য last order দিন। Last order দাও।
কালকে ওরা রিসিভও করেছে।
They have received us the reply what we have filed. We have served them the reply on copy দিয়েছে।
Yes, Imon Bhattacharya appeared.
Yes. The reply was served on them. They have received also Imon Bhattacharya. Maybe serve a notice. The reply be taken on record.
But let the opposition first.
মন কেউ তো কোম্পানি কেউ
একদম আমি বই তারপরে জিনিস লস করে
that matter.
Is that matter, Millard?
Restoration.
Yes. Now, since Millard, I presume Millard Lordship was Millard, the order of 13, na? CA 13, jeta.
CA 13 হয়ে গেছে, ভালো হয়ে গেছে। শুধু CA 406।
CA 406, that's the restoration application that has
Restoration of the
main company petition, Millard. The Lordship takes Millard only one paragraph, Millard. Paragraph 9 of our petition, Millard.
4066 recalling of which order, Mr.
This is recalling of
9th of June.
9th of June
2014.
2014.
At page 30.
That's at page 13.
Page 13.
30.
Oh.
Corresponding.
Filed after 1 year.
Sorry?
Yes.
Filed almost after 1 year.
After 1 year.
After 1 year.
Serve the other side then.
Readings below page 50, para 50.
We will, Millard.
Because it's after 1 year, let them come. I'll restore, but after hearing them.
Fair enough, Millard.
Main CP টাও appear করতে
Serve the company.
We will, and also let the main CP also appear, Millard. Lordship can dispose of both of them, Millard. If it is restored, then because there's already an order passed by Millard Justice Banerjee, Millard, as his Lordship then was, Millard, that would appear at Millard.
That has been stated. Page 22.
Page 22, there was a part admission on the part of the company, Millard. That was, Millard, admitted to the sum of 14 lakhs. But I will argue on once the company, Millard, is represented, Millard.
There was an SLP of remand.
There was an SLP file. Well, a lot of things have happened in the meantime, Millard. So
let
the company come, Millard. Lordship will come.
This is an application for restoration. Next.
Grateful,
My lord, my lord. Miss S. Pal is appearing for the official liquidator, my lord. She is engaged in another court, my lord. Kindly make it not today, my lord. On behalf of S. Pal, I am praying to not today.
And on 22nd of July, my lord took up this matter. My lord directed them to file a report. What has happened, my lord? The petitioners are the ex-workers of the liquidated company, and I have already indicated that I am in the similar footing as in the appellants of APO 169, where the money was disbursed. And that in that regard, my lord directed them to file a report.
My lord, I am only praying not today, my lord. I am only praying not today. She is engaged in court number 36, my lord.
The official liquidator is there with the report. The report can be taken up.
A copy of the report.
My lord, kindly take this report and kindly give us the next hearing date, my lord.
Yes, give it.
My lord, copy.
The report filed by the official liquidator is taken on record. A copy thereof has been served upon the learned advocate appearing for the petitioner, who's as prayed for, list this matter after a week.
Very good. Deep Lord.
I'm grateful, my lord. I'm grateful.
Next.
6 and 7.
My lord, item same matter, my lord, 6 and 7.
Same order.
And that is
6 and 7 একসঙ্গে করে দিন।
my lord had directed to file single.
Only one report will be একসঙ্গে করে দিন, দুটোর অর্ডার একসঙ্গে, দুটো কস্ট টাইটেল একসঙ্গে দিয়ে কমন অর্ডার করুন।
My lord, I am for the official liquidator, my lord. Today I have received the brief. It's a change brief, but there are two applications. One application by the official liquidator, that is CA number 10, for disbursement of the sale proceeds. Where, my lord, one of the secured creditors, one of the creditors, if I may say so, they have raised an objection with regard to that why they will tax department.
I am the commercial taxes department.
Why
That
they
is
will
what
be treated as a secured creditor under section 529A. That is the only dispute. Otherwise, everything is ready for making the payment. My lord, according to me,
The contention is that they should be treated as secured.
I'll just indicate, but that is perhaps not the point.
My application is there, my lord. I'll indicate, my lord, I am the secured creditor. The proceeds have now come, my lord, for distribution. My lord, I am seeking priority of payment. The commercial tax department, whom my learned senior friend is, my lord, representing, my lord, seeks a priority over the secured creditor. My lord, that's the limited point of argument. My lord, the only difficulty, my lord, under instruction I'm submitting, my lord, Mrs. Manju Bhuteria is leading me, but she has some personal difficulty. This matter can be posted next Wednesday for hearing.
There's only one issue, my lord. My lord, they are claiming to be a secured creditor because they held an asset. As a security interest was created over that asset. Post liquidation, they have themselves surrendered that right in favor of the official liquidator. So once you have given up your possession and the mortgage rights,
They have relinquished their security.
so then you cease to remain a secured creditor.
You mean to say they have relinquished their security interests?
They have themselves admitted in their application. So once that stage is gone, where they are no longer holding a security interest, then they come in the line of, my lord, the line of creditors. Now, once that happens, my lord, as a commercial tax authority, as a taxing authority, my claim will have priority under 529A, and only the laborers' rights and provident fund dues, gratuity dues, can have a priority over the tax dues. That is my only contention.
They have
That's a point of dispute.
That's a question of law.
That's also a point of dispute because our case is that there has been no relinquishment of.
Next week she will be available. Next week she will be available.
The 26th, if your lordships can keep it, my lord.
I have no difficulty. I'll be here.
Yes, Mr. Chaudhary.
26th.
no problem, my lord. I would like to file and reply because they commercial tax, they have filed an objection with regard to
File a reply to their
yes of the objection.
Very well. लिखे नहीं. Mr. Chaudhary, learned advocate appearing for the
My lord,
Your lordships, I appear for the appellant. I'm led by Mr.
item
Sonak.
9.
He's on.
I am for the respondent, my lord. This is my application, which is, I'm led by Mr. Mitro. Mr. Mitro is there.
My lord, there is a development which can perhaps avoid today's hearing. My lord, from a High Court order, we went up to Honorable Supreme Court. 31st July, the Supreme Court has expressed a view that it should be referred to mediation between the parties. If the learned Advocate General and your Lordship has a look at that, perhaps we can save our ammunition for today. Kindly have a look at the Supreme Court's order. This is the view expressed by the Supreme Court. We can try and resolve it amicably.
My lord, only thing is, my lord, the disputes are pending for long.
Yes.
Now, the parties, my lord, they can, my lord, if they can amicably settle.
Amicably settled, then.
Then, my lord, but this is, my lord, fixed on 23rd of September, my lord, practically, my lord, the vacation would be on. So, my lord, I would humbly submit, my lord, lordship will kindly keep this, my lord, application for hearing. A short point, my lord, in our respectful submission, my lord, that is the application that, my lord, their 10F appeal, they had preferred an appeal in terms of the provisions of the Companies Act, my lord, the old Companies Act, 1956 Act, from an order passed by the Company Law Board. According to us, my lord, in view of a division bench judgment of this honorable court, my lord, the appeal has really become infructuous. So, my lord, if your lordship is pleased to hear out my application, in the meantime, my lord, if the parties or my lord, thereafter, if the parties can settle, that would be.
A view has been expressed by the Honorable Supreme Court.
And
should not once try.
That's
and
true.
Lord, can I just
But, my
clarify?
lord,
Can I just?
they can continue
just
trying,
clarify?
my lord. I was
Can
only
I-
humbly submitting that.
Yes.
Can I just
Disposition of the
clarify one thing?
application, my application or my lord, the main application by your lordship, it will not take long.
Lord,
Now, my lord, will really not prevent, my lord, the parties from settling.
My lord, with the learned Advocate General and your leave, my lord, I am the 10F appellant. My learned friend, senior friend, has taken out this application saying the division bench has rejected my prayer in a writ petition. It is against that division bench order that I filed the SLP in which this order is passed. So it is inextricably correct.
True. Even before that, my lord, I can show your lordship's the judgment by the Supreme Court between the same parties, which, my lord, really says, my lord, that the my lord, appellant before your lordship or the petitioner before your lordship is abusing the process. That is.
Mr. Mitra, in view of this development on 31st of July 2026.
This really does not prevent, my lord, in my
It doesn't prevent, but there is a view expressed. If I preempt this, it will be a sort of preempting this view where the Honorable Supreme Court is exploring possibility of mediation. I'm in the meantime bulldozing it by passing orders. This we can have it any day after the Honorable Supreme Court's.
My lord, in that event, I would, my lord, I shall tell your lordship, my lord, my client, my lord, the real person, my lord, he is, my lord, an octogenarian. My lord, he wants to, my lord, finish the things off. So, my lord, it is fixed on, my lord, 23rd of September. Kindly keep, my lord, 24th or, my lord, any other day. My lord.
Very fair. Absolutely. No difficulty.
Mr. Shonok Mitro, learned advocate, appearing for the. You are appearing for?
I'm the appellant in the section 10F appeal. And the respondent in this application.
In the appearing, you are appearing for all the respondents.
No, my lord, not all.
Point number 1.
There are 4.
Only one.
One. Which one? One. For the respondent number 1.
My lord, the application, the instant application, my lord, for my lord, dismissal is by the respondent number 1, Ruby.
Oh.
They are appearing for the appellants, my
For
lord.
the appellant in.
Appellant in the section 10F.
APO 156 of 2015.
Lordship, my lord.
Learned advocate appearing for the appellant in APO 156 of 2015, submits that challenging an order passed by this court on a writ petition, who had approached
Your Lordship, the
My
appellant.
lord, I have approached the Supreme Court. I have approached.
The appellant has approached the honorable, but the appellant in the appeal is Ruby General Hospital. The cost title
No.
before the Supreme
Says
Court.
Sajal Datta.
No, my lord. Sajal Datta. Sajal Datta is the
So
appellant.
therefore, Mr. Mitro's client had, learned advocate general's client had approached the Supreme Court.
No.
No. I have approached. My client's name is
Sajal
Sajal
Datta has
Datta.
approached.
Petitioner.
My name is Sajal Datta.
Yes, but here Ruby General Hospital is the appellant in the 10F appeal.
No, my lord.
No.
Sajal Datta is the
Lordship
appellant.
is
Sajal
looking
Datta
into
is-
the order, my lord,
I am looking at the cost title.
No, Sajal Datta is the
of
appellant.
the order of 31st July.
Yes, 31st July. Sajal Datta is the petitioner there.
Yes.
You are representing.
And Sajal Datta
I
is
am
also the
appearing
appellant.
for Ruby General, my lord.
And they are representing.
They are appearing for my lord Sajal.
Mr. Mitro, learned advocate, appearing for the appellant in APO 156 of 2026. Hands up to court a copy of an order dated July 31, 2026, passed by the Honorable Supreme Court in SLP 10755 of 2026, and submits that the appellant has approached the Honorable Supreme Court against an order passed by this court on a writ petition. Who had filed the writ petition?
My lord, I had filed the writ petition. I lost it before the single judge and the division bench.
Filed by the petitioner, that was affirmed by the Honorable Division Bench of this court, wherein, the Honorable Supreme Court has issued notice making the matter returnable on September 23, 2026, within inverted commas, for the purpose of exploring the possibility of resolving the dispute between the parties through mediation, as the dispute is between two brothers, inverted comma closed, full stop. In such view of the matter, since the Honorable Supreme Court has expressed its view to explore the possibility of resolution of the dispute by way of mediation, it would be proper to adjourn this matter to a date later than the date on which the matter is made returnable before the Honorable Supreme Court. Full stop. Accordingly, list this matter on September 30, 2026.
Grateful.
Grateful.
May I file the affidavit of service?
Yes. Affidavit of service filed in court today, taken on record.
Grateful.
I was assisting Mr. Mitro.
September.
My lord, I am for the official liquidator.
I appeal for the reasonable purpose, RP.
My lord,
RP.
we have received written instructions from our client to withdraw the matter, my lord. This is the written instruction.
Learned advocate,
My lord,
for the petitioner.
if
Hands up to court.
my lord, if leave be granted to file before NCLT, my lord.
There cannot be
hands up to
specific
court.
leave. There may be in accordance with law, my lord.
A letter dated July 31, 2020.
Release.
I see the last day's order, Lordship is.
My petition, I had a petition also, my lord, which is now being.
Release. This matter stands released from this list on my personal grounds. Let this be placed before the Honorable the Chief Justice, Acting Chief Justice.
My lord, 12 is also a similar matter, my lord. Corporate Ispat only, my lord. Some other application, my lord. I'm just praying that the same may be tagged with the last application which was.
Has to be, it will come up in the list. I'll release it.
It is today listed as item number 12, my lord.
It will be called. I'll release immediately. Thank you. Same order.
My lord, it may be tagged with CA 16, my
I am
lord.
releasing it. I cannot pass order of tagging. Whenever it goes.
Much obliged.
This is my application.
Yes, I remember. I'll call for a report from the department.
Regarding the CP, Your Lordship?
Yes, because the official liquidator had also filed a report. I
filed a report. We have a copy of the report, Lordship.
Yes. Then it must have been in respect of a CP. How could a CA be filed without a CP being there?
Now, I'll tell you what has happened, Lordship. We were not able to get the CP. So we mentioned this matter before Lordship Professional Rao, that we are unable to find the CP. So he said, okay, then file an application as to what exactly you are looking at by the application. Now,
Yes. Let us have a report from the department as regards the status of the CP, what has happened, where are the records. Something must be there from the department for us to proceed further then.
I truly appreciate your Lordship. I truly appreciate it because we tried to search for the CP even in the office of the OL. We could not get anywhere.
I'll direct service of this application on the OL also, because he might be also having something that might provide an inkling to the application.
We will serve this copy to the OL. No.
This application has been filed.
the respondents. 17 টা আলাদা matter.
What was the matter?
Matter is, my lord, after disconnection, they have reconnected. Somehow we have an inspecting team. It was found out, coach attended. Provisional assessment bill was raised. They have challenged. Prior to that, there is an outstanding dues also for 2024 to 25.
They are challenging the assessment order.
Not assessment order, my lord. They are challenging same that one Obhijit Das says, I am not the occupier of the premises. We are not claiming against Obhijit Das. We have claim against Bubai Das, son of Sikha Das. Sikha Das is the original consumer and Bubai Das.
The connection is not in the name of Abhijit Das.
Not in the name of Obhijit Das. So who is Obhijit Das? We do not know. How he has filed this writ petition? One advocate was appeared on earlier occasions. But on inquiry, it has came to the knowledge of the officers that the Bubai Das also called as Obhijit Das. Same and identical persons. That our office.
In the writ petition, is that his case that he has an alias? No.
No.
Yes. No. His case is different. Against one Bubai Das is
Yes,
his case.
yes. Our officers inquire into the matter after being taken up by this honorable court. I advise. They say that yes, Obhijit Das and Bubai Das is same and identical persons as they have gathered from the local villagers. But actual consumer is Sikha Das.
But the case is that the meter is not in the name of Bubai Das.
Bubai Das is the son of Sikha Das and he is the user. So son and mother. Sikha Das is the consumer. And he has written letter. I have submitted the report. Your lordships kindly have a look to the report.
For the petitioner, 18.
Well, yesterday in a similar matter,
Item
For
33.
you are appearing.
Lordship
There was a direction to file a report by the
corporation, my lord,
Corporation.
there is a confusion about the
And I remember, second floor, you are
Yes, yes,
here
your
also you are in second floor.
Here you lordship on first floor.
First floor is
Yes.
authorized.
Yes, your lord. G+2 is authorized.
Item 18 and for the CC Limited, first floor, there was a direction for a report to be filed.
By the KMC.
You are appearing in 18, 19 only or 18, 19, 20?
18 and 19.
20 you are not appearing. 18 আর 19 এই অর্ডারটা রেকর্ড করবে আলাদা আলাদা একই অর্ডার হবে আলাদা আলাদা করবে
বুঝছি আলাদা
19 এ আলাদা কিন্তু অর্ডার একই হবে মানে বডিতে একই থাকবে জাস্ট ছাপবেন আলাদা আলাদা ফার্স্ট টাইটেল আলাদা দেয় একটাই সব ছেপে দেবেন লিখে নিন বাই দি অর্ডার There, she has there. Survey notice on KMC. Liken in affidavit of service filed in court today is taken on record. The
দিয়েছি 20 নাম দিয়েছি, দেখুন তো সোমনাথ ঘোষ লেখা স্লিপ দেখুন, আরেকটা দিয়ে দিচ্ছি।
21, Lordship, I'm praying for not today.
not today.
Matter can be disposed of. I will candidly specify before Lordship. These orders which has been challenged is to be set aside. Why I'm telling you, it's an accident claim case. And there was this is a second round of litigation. Before Lordship, I am not on that, but there will be no adverse order against the petitioner. This order has been passed by the station manager. So station manager has got no domain to hear the accident claim case. The concerned zonal manager or the authorized representative should hear this matter, Lordship.
Is there any law on this that?
Yes, a law means there are other orders are also there passed by this coordinate bench. So far the accident claim is concerned, that is to be heard by the either by the zonal manager or his representative. Your Lordship also passed certain order.
That was not because of any policy or
No,
any
no, not against any policy. So far, the chief electrical inspector is concerned under section 161 that whenever the accident has been made, immediate intimation is to be made.
Time, let her come, then we shall see. Chalo. Not today.
For the petitioner, on last occasion, your Lordship seek a report from the CSC. This is a matter relating to the unauthorized transfer of electricity.
We have filed a report, my lord, will kindly come. And let there be a judicial order, my lord, we can revert back on this. We have transferred it on basis of the applications which have been filed by the private respondent on good faith. We found that it is the petitioner is the wife of the erstwhile consumer. We will revert it back in the name.
Lordship, my respectful submission, petitioner filed this writ petition suppression of fact. Same cell grounded shoot for declaration was pending before the trial court. And that shoot, I filed a written statement, injunction was passed. Thereafter, order 39, rule 7 was filed. That was allowed. Petitioner challenged that order. Preference here, civil division application before this court. That was still pending. Lordship, I hand over. But how could you get his meter transferred in your name? Okay. This meter fully in my name. My sole property.
Your Lordship.
My meter was earlier in the writ petitioner's name.
Yes, your Lordship.
Got it transferred in your name. How?
It was in writ petitioner's husband's name.
Yes, your Lordship.
Very well. From the writ petitioner's husband's name, you got it. Who are you?
The brother-in-law, your Lordship.
You are the brother-in-law. So how could you get it transferred from the name of the writ petitioner's brother to your own name? That respect of property, I had a trade license Previous date. I hand over this document.
Yes.
Before transfer lordship, the year 2017, I hold the trade license from the corporation prior to the transfer in their name.
You are Mazharul Haq.
Yes.
What is your name?
Mazharul Haq, Your Lordship.
You are Mazharul Haq.
He has the electricity in his name, and again, one new connection has also been supplied.
Already have electricity supply.
Yes, Your Lordship. Yes, Your Lordship. Still enjoying that electricity.
There will only two things, my lord. I will kindly come to page 4, paragraph 6. When I should not point it out, my lord.
Page 4 of writ petition.
Yes, paragraph 6.
I don't have a document.
Last line, my lord, last 3 words. 24/5/2020. Now, my lord, kindly see my report, annexure A2, that is of 19/11/2020. That is the no objections from the life consumer.
Page?
My report which I have just submitted.
Yes.
I will kindly come to my lord. First is this the annexure A1.
No objection from
That is 19/11/20 from the live consumer.
yes. The consumer died on 24th of May 2020. How could you give the no objection on 19/11/2020 after his death?
In this matter, led by Mr. Sanjay Mukherjee. He is engaged in another court. If it's short possible, Lordship, kindly.
What kind of password?
Kindly short possible, Lordship.
No, you take.
Short possible.
It will not make any difference in any case.
Short possible.
He's a junior member, let him come. Ask your senior to come.
Your Lordship, may I mean?
Pass over. Yes.
Ashish, but I am for the respondents in this matter.
What is the scan for?
One application for addition of party was filed. Somebody.
And what is the main writ petition for?
Main writ petition, he is asking for shifting on to polls, but he has not applied any prescribed format. That's my instructions. But however, the court, my lord, even we have informed that one civil suit is pending between the private respondent, the applicant who has filed this addition of parties applications. Anyway, my lord, the court directed me to file a report. I can file the report and for
appears for the petition.
আমি রেসপন্ডেন্ট আপনার রেসপন্ডেন্ট আমি WBS edition. Well, I'm for the WBS edition.
The private response.
Same order.
Well, perhaps it is not maintained.
My lord,
asking for the removal of the.
Very well. So in their absence, I cannot.
My lord,
dismiss it.
direction was given, my lord, to file report. My lord, let it be filed today.
May I get a copy of that?
Report filed on behalf of respondent WBS judicial authorities is taken on record.
My lord, I am appearing in this matter, my lord. Item number 25, I am appearing for the petitioner. My lord, in this matter, what has happened, the scheduled tribe property has been mortgaged, which is in violation of section 14B of the West Bengal Land Reforms Act. My lord, SARFAESI proceeding has been initiated. Thereafter, the section 14 notice has been set aside by the learned DRT, my lord. Thereafter, only on the point of technical issues, my lord, 9-point affidavit has not been properly filed. Thereafter, fresh section 14 proceeding has been filed by the bank. But the thing is that, my lord, in this matter, I am not challenging on SARFAESI action, SARFAESI proceeding. My prayer is limited only to the extent whether a scheduled tribe property can be mortgaged by the bank in violation of section 14B of the West Bengal Land Reforms Act. My lord, kindly seize the act. Because SARFAESI forum has no jurisdiction over land reforms, that's why I went up before the Honorable High Court. Only High Court can decide my statutory right violation, my lord, my legal right violation. I, being a scheduled tribe member, whether my property can be mortgaged without the NOC of the revenue officer.
Was it done forcefully? You did not offer it for mortgaging.
My lord, I have applied and they have sought for the NOC to bring NOC from the municipality. Municipality is not the competent authority as per the act, my lord. My lord, they have sought NOC from the municipality, not I.
Who is appearing for the bank?
My lord, my learned friend was appearing. I have served him the notice and informed him also over the phone.
Very well, you serve one more notice. Nobody is here.
My lord, the thing is that the CGM has granted me last opportunity, so kindly keep it on tomorrow or day after tomorrow so that
you convince the CGM there. Because of the CGM's urgency, I will not be able to make it urgent.
My lords,
can come.
My lords,
the petitioner shall serve a fresh notice on the respondents, intimating them that the matter will be taken up next on August 24, 2026. Petitioner shall file affidavit of service on the returnable date.
Grateful, my lords.
Next.
26 for the petitioner. This matter has become infructuous, so I'm withdrawing the matter.
I think it has been already amicably settled. Because 16,000 something was due.
You have a letter to put on record.
No, our grievance was that electricity was not being provided to us. And therefore, yes.
Electricity has been given to him. No, I think will not do. Please be sure. I'm making it not today. Come and make your submission.
As per our instruction, as per mine.
Something to keep it on record.
Petitioner told that he has already.
Bring a letter.
Yeah,
yes, next.
It is urgent, Lordship?
Not today.
Item number 27, Lordship, may I be allowed to appear virtually? I apologize, Lordship. I'm not there in court. May I be allowed to appear virtually? But, Lordship, this is my application praying for an expeditious disposal of the Section 14 pending before the learned SEJM Baruipur, Lordship. This has come.
SEJM has passed the order, I think, but it is the pending for the DM, not Chobis Pargana, South Chobis Pargana.
No, it is pending before the SEJM.
SEJM Baruipur, Lordship. The last order records the same.
SEJM. Direction may be given, my lord. I will communicate, my lord, with you shortly.
This writ petition seeks expeditious disposal.
Lordship, I appear for the bank.
Of an application under Section 14 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, pending before the learned Additional Chief Judicial Magistrate, Baruipur, South 24 Parganas. Full stop. The same has been registered as Miss Criminal Case 39 of 2025. full stop, paragraph, learned advocate appearing for the petitioner submits that the said application under section 14 of the 2002 Act has been pending since May 2, 2025. Full stop. Having heard the learned advocates appearing for the respective parties and having considered the material on record, this application is disposed of by requesting the learned additional chief judicial magistrate, Baripur, South 24 Parganas to dispose of the petitioner's application under section 14 of the 2002 Act, being Miss CRL case 39 of 2025, as expeditiously as possible and preferably within a period of 1 month from the date of communication of this order. Full stop. Paragraph. WPA 9738 of 2026 stands disposed of. No costs.
Grateful, my lord.
I'm good.
Next.
না না এক মাসের মধ্যে করে হ্যাঁ ওরা কমিউনিকেট করে দেবে 1 মাসের মধ্যে করতে হবে।
I am for the petitioner, my lord.
My lord, I
In
appeal
this,
for the
this
respondent,
is
my lord.
a case where
Before my learners,
the electricity company,
may I say just one thing? Respondent has admitted into CIRP under the Insolvency and Bankruptcy Code, my lord.
that doesn't affect writ petitions, my lord.
My lord, because there is then the writ petition, my lord. I have also filed a CAN application to this regard. Section under the moratorium and the section 14, my lord, no proceeding, my lord, knows can continue, my lord.
Well, that is
Firstly-
not the law, madam.
Yes, my lord.
So let me proceed with my case. Let me
My lord, the section
let me
14
finish. Then
is there,
Learned
my lord.
will make his submissions, and then my lord will decide.
My lord, will kindly say section 14 of the Insolvency and Bankruptcy Code, my lord. My lord, any
Will also
proceeding, my
take
lord,
the
cannot proceed against the
Paragraph
corporate debtor.
31 of the petition.
And my lord,
Paragraph 31 of the petition, madam.
But what will happen to the moratorium? No proceeding can continue.
My lord,
against
writ
the-
petition is not a proceeding with a meaning of section 14. I'll satisfy that. Before that, my lord, this I cannot proceed today because interim resolution professional has to be added as a party. So lordship grant me leave to add interim resolution professional within certain time and to amend the cost title, serve him, then we come back, my lord.
Very well. Sir Sarkar, learned senior advocate appearing for the petitioner submits that the respondent number 1 has been admitted for corporate insolvency resolution process by an order dated
15th May 2026, passed by NCLT Hyderabad.
26, passed by the National Company Law Tribunal, Hyderabad. Full stop. It is submitted that in such view of the matter, the respondent number 1 would be required to be represented by the interim resolution professional, and therefore, the interim resolution professional would be required to be added as a party.
Lordship.
Full stop. As prayed for, leave is granted to the petitioner to amend the cost title appropriately.
To add.
You will add, or this will be represented by the
My lord, may I?
Represented by, lordship is right, lordship is right.
You'll argue that. You'll argue that. Let him amend the cost title. You will
Matter is
argue
not being heard.
the petition is there. You will not argue in air. You have to argue for you to argue the point of maintainability. The IRP has to be there. Right now, there is no company,
Very well,
no
ma'am.
face.
Very,
The company can be represented by
Has
the
to be-
IRP only.
very well.
So for you to be here, somebody should be there. Who are you representing today? Nobody is there. The company is in CIRP.
I bow down to that,
It
man.
doesn't have a face as of now.
If only my lord requires one sentence saying that the maintainability be kept.
But you have to argue once the writ petition is in order. Let
Very
it be in order first. It's not in order now. Likhud. As prayed for, liberty is granted to amend the cost title of the writ petition appropriately, so as to include the interim resolution professional.
And a copy of the repression will serve.
Stop. A copy of the writ petition shall be served upon the interim resolution professional within
15 days, my lord.
within 2 weeks from date. Full stop.
List this.
Or if my learned friend can accept service on behalf of IR.
I am not the advocate on record, so my lord kindly permits them to serve.
Then,
We will accept service.
then who are you appearing for?
But I am appearing for the interim resolution professional.
Then,
He is to be added as party.
so I can serve him.
Yes, my lord, but I am not the advocate on record. Let him serve on my advocate on record.
Then
my lord.
Yes,
take your
yes.
seat. Then you are nobody. Then you are representing the interim resolution professional. Then you are not representing the interim resolution.
I do not have
professional.
I do not have the wakal. My lord, may I just say this? I do not have the wakalat nama, my lord, because I am a member of the Bar Library
Then
Club.
you don't have authority. Chalo.
My learned friend is Mr. India.
Mr.
You cannot have a wakalat nama, my lord, due to the Bar Library Club. I'll indicate the name of my award
Let's
in
not
the.
waste time. Let
No,
it
no,
be.
I'll indicate the name of my award in the attendance sheet.
I'm appearing for the
Upon the
interim.
professional within 2 weeks from date. Full stop. List this matter on 26th August 2026. The petitioner shall file affidavit of service on the returnable date.
I am appearing for interim resolution professional led by Mr. Mitra.
How many people
He
appearing?
is my advocate on record, my lord.
I am the advocate on
Well,
record.
advocate on record.
I can accept service.
Yourself don't have wakalatnama. How can there be an advocate on record of yours who does not have a
All
wakalatnama?
right, we'll do the necessary. We'll do the necessary work.
May I have a kind indulgence? Item 144 is an identical matter. Same party, they can be tagged also together.
Very difficult. Let us go because the file will not be traceable immediately. 144 down.
I see.
Once it is called on.
No sure. I will remind you.
Yes, sure. If we were closer to that number, we could have done it. We are too far. 120, 144 and
Lordship, I am for the petitioner in item number 29. Lordship, the case is that petitioner is the owner of a premises, Lordship. Now, the private respondent number 6, who is residing approximately 200 meters away from the petitioner's premises in a different house, have installed a electricity connection in the premises of the petitioner's meter board. And now, Lordship, kindly comes to the photographs that I have annexed with the writ petition. It starts from page 22. From the
22.
It starts from page 22. From the said electric meter of the electric meter board room, the wiring of the private respondent's connection is going in this manner, Lordship. In a very unsafe and hazardous condition, it can create a fire hazard any time to the petitioner. And this monsoon, it can now, Lordship, the matter was heard before Justice Kapoor. Justice Kapoor directed the CSC authority to file report.
Yes, Mr. Mukherjee, what are you doing?
Well, the report has already been filed.
No,
Subsequent.
but what about this wire? This way, if it
Well,
goes-
this is the wire of the private respondent. The connection was given 22 years back. For 22 years, no monsoon and no winter has affected. Suddenly, it has affected, my lord. Well, there was a direction, my lord, to hold a settlement
On the
meeting.
last occasion, private respondents appeared.
I have, my lord, intimated the CSC, probably they don't want to. My lord, without the private respondent, I don't think, my lord, can kindly see my
lifting of their meters.
Yes.
Shifting, disconnection.
My lord, in the report, why
Shifting,
I say,
only removal from my premises, Lordship.
my lord, why I say, my lord, the private respondent is necessary, my lord, kindly see my report dated 15th of May 26. I will only request your lordship to peruse, my lord, page number 2, clause number 4 and 5.
Report?
Clause number 4 and 5. Roman 4 and 5, my lord. Well, this is
He is
what
willing to apply for a new connection at his own plot.
Yes, that is the reason, my lord, I submitted unless the private respondent is here.
He may get this disconnected on his own because according to CSC, he is willing to apply for a new connection at his own plot.
In the meantime, my instruction that he has not applied.
Very well. With this notice, he will come.
So on the last occasion, he appeared.
No, because I think, my lord, my learned friend has mentioned this matter without notice.
Oh,
Only
that
for
may be
inclusion in the list.
that may be a reason. Inclusion in the list means what? It will appear. It will not be taken up. Samarda লিখে নিন
the electricity supply was sought to be transferred by way of an application in the name of a person who died
prior to
5 months prior to
it
that.
appears from this report, my lord, for my own satisfaction, kindly keeps it day after. Let me take instructions and come back.
It's the licensee's records which show that your
Yes,
application
I will not
is
be able to change it.
subsequent to the date of death and in the name of the dead person.
There are certain suits are also pending.
Maybe, but that is not relevant. You also know that if suppression of every fact is not fatal for the
Lordship,
petition.
kindly keep it.
You have to show that
That's
the
why
fact was relevant and material.
Yes,
Pendency of suit is not relevant for the purpose of transfer.
Lordship kindly keeps it day after. Let me take instruction and come. Just on this point, no other point. Before conceding, let me take instructions.
আমিও জানি না যে whether 24 ছিল, but it has been
Death certificate. It is in annexure.
By
Annexure was.
Das learned advocate appearing
Annexure
in
P1.
number 4, comma.
P2, 17.
This matter, দিদি এটা নিউ মোশনে দিয়ে দেবে as a new motion.
আমি একবার ক্লায়েন্টের সাথে কথা বলবো।
My lord, I appear for the petition. My lord, in this matter, petitioner is seeking for a fresh electric connection, my lord. On previous occasion, the coordinate bench directed the authorities to inspect my premises and file a report. My lord, as far as my instruction is there, inspection done, but report has not been
My
filed.
lord, I am filing a report, my lord. Inadvertently, my lord, it could not be served. But my lord, case is such, my lord, a splitting up of load. That is not permissible. And my lord, from the averments, of course, my lord, he has right to make an exception. Averments in the writ petition clearly states this case of splitting up of load. And the father of the petitioner, in whose name a connection is there, he has come and affirmed this affidavit.
My lord, petitioner.
Lordship, kindly see the affidavit portion. Adhir Pal, in whose name the father of the petitioner, in whose.
My lord, at that time, petitioner was admitted in hospital, my lord.
No?
At that time, my lord, the petitioner was admitted in hospital. That's why one of petitioner's father.
That's right, but
My lord, there are two different premises, my lord.
what is your inspection report showing?
Yes, my lord, same premises. I have
Actually, there
made
are
it clear in the
premises,
report.
my lord. I shall come back with an exception, my lord.
Come back unnecessarily. Why are you
My lord,
prolonging it?
kindly, my lord, 1 week.
It has to go. You can approach the GRO immediately and get it settled. GRO is the authority.
My lord.
If there is a case of split load, you have to approach the grievance redressal office.
Lordship, kindly, my lord, have a look, my lord, to paragraph 7.
Let him come with the exception.
Paragraph 7.
Let him take the exception.
Right.
Report filed on behalf of the respondent, WBSC.
Is running a commercial business lordship, having trade license, applied for a commercial connection. No steps were taken. Thereafter, there was a direction to file report, lordship.
My lord, pursuant to 15 June's order, my lord, I am filing this report.
Lordship, I have not received the copy of
My lord,
it.
I am serving here and now.
What is the matter? Why are you not giving him supply?
My lord, the petitioner has to provide a feasible position, my lord. My relevant paragraphs are paragraph number 4 and paragraph number 5 of the report, my lord.
They say there is no space in
Yes,
the
my
meter.
lord. And by
Lordship,
paragraph
my
number
instruction
5.
is that during pendency of this writ petition, another meter has been installed in the said meter room. And the condition
They
of
have provided a space, my lord. There are 40, it has been
the
admitted that
petition
there are
was still
40
pending.
applications which are pending right now.
They might have provided a space, doesn't make any sense. If there was no space, how will they provide a space?
No, my lord,
If there is no space,
kindly peruse
try
this.
to understand the court's query, then you will be able to answer it better.
My
If
lord.
there is no space, space cannot be built out of air. There has to be space. If there was space, then he was first in the queue. You should have provided him.
But
How could
there
you
is no
jump?
such instruction on my part that something new has been
Then you
installed.
take
And
instruction.
that is also not on record, my lord. What is
That will come on record because your report is coming today. So he will come on record with the
Let him
exception.
find an exception to this.
He will
My
file
lord.
the exception, but you also have to
My
answer
lord,
this.
I am taking instruction in this role.
You also have to answer it.
My lord.
Before jumping to conclusions, have patience to hear out.
Lordship, another, what I am praying at this stage, another inspection be carried out to take out the feasible position.
Take exception to this, bring that fact out,
Lordship,
then question of
Lordship,
inspection will
Lordship.
arise.
Lordship, 2 weeks time I will come with the exception.
Report filed on behalf of CSC
Okay,
Limited is
good.
taken on record.
I am for the petition, Lordship.
I appeal on behalf of
Lordship,
WPSC.
this is a connection for submersible pump. The connection is running by means of temporary structure, bamboo and temporary means. Petitioner prayed for transformation of the said connection into a permanent connection by installing poles and transformer. Thereafter,
Yes, Mr. Mukherjee, why are you not
Well,
doing
we have filed a report on the last occasion, my lord. But since, my lord, the cultivation is going on, the field are very muddy. We cannot, my lord, erect the poles, my lord. My lord, as per my instruction, my lord, this can only be done in the month of October and November. And my lord, there is an amount of rupees
that has been paid.
34,955.
That has been paid. That has been paid.
If he has said it is
That has been paid. I am submitting on the instruction, Lordship.
Very well, then I'm disposing this off. Once the water recedes, please do that.
My lord, kindly peruse my report dated 23rd
I have
of.
seen.
Yes.
You have said after 120 days, subject to availability of
Proper
bailiff
very permission, yes.
Believe there is a problem.
No, Lordship. Lordship, I am praying within October the connection may be completed, Lordship.
I will say the water has to recede. Suppose before October there is a heavy downpour, then it will depend on the. I will indicate that. Don't worry. The petitioner complains of inaction on the part
directed by the Honorable Court.
My lord, in the previous order, my lord, his lordship, my lord, Justice Kapoor has directed to impede the, my lord, private respondent who was obstructing the electricity connection. My lord, I have amended the cost title of the petition, my lord, and this is my affidavit of service. My lord, in spite of, my lord, paying the quotation amount, my lord, electricity authority till today, my lord, not granted electric connection at the premises of the petitioner, my lord. Petitioner has deposited, my lord, 2,82,000, my lord, money to the concerned, my lord, CSE authority.
Who are you, tenant?
No, my petitioner is the, my lord, developer of the building, my lord.
And who is obstructing?
My lord, some third party, my lord, some owners.
The fact is that, the land is divided, the plot is divided into two portions. Admittedly, the petitioner has complied with the formalities. We had been there, and the pipeline, according to our understanding, has been laid down in an undemarcated land. When we went there further to lay the cable, my lord, we have been vehemently objected by one my lord. Her name is there. One my lord. Sabina Yasmin, who is the Milord sister-in-law of the petitioner, and Milord claiming herself to be the owner of that particular land where the pipe has been laid down already. So, Milord, we have already learned that, Milord, that a case is also pending. So, Milord, if your lordship so directs, Milord, we can go ahead with police help, Milord, and provide the complete
one more
process.
notice, since this notice is old. So
My lord, the case which was pending was amicably settled.
let her come once. Affidavit of service filed.
Well, 12th August.
My lord, item 34, I'm praying for a short passover, my lord, on the ground of passing.
Seconded on some other day. 3:30 I have a matter, Milord, takes before the Honorable Division Bench. Before my Lord Justice Shampa Shaka, Milord.
Not today. Not today.
No, the interim order, the interim order be extended, Milord, for a day or two.
There, is it there? It is limited.
Till today, Milord, the interim order. Till 4th of August, Milord, the interim order was there, Milord, not to take any questions. Milord, this is the matter where the school was involved. Late payment charges, Mr. Devjit Mukherjee, Milord, was appearing.
Dikhenin, and accommodation is sought
My lord, 35 I paid for not this month, my lord, due to petitioner's.
So,
My lord, I'm sorry, that
I'm from the state.
third occasion, my lord.
no. I now finish it. Last time also you had prayed for, I had granted you time.
Third occasion, my
This
lord.
is the third occasion.
My lord, they have challenged
Even earlier you had prayed for, this is the third time. No.
without exhausting the alternative remedy, that's challenged service proceeding without going to the DRT under section 17. That is the
DRT is the proper forum.
only thing.
Dikhenin.
Injured, my lord. It is
action with help
Very
of
well.
police action.
You give one more notice to them.
Very well,
Take it
Lordship.
up.
Very
Taken
well.
it. Report filed on behalf.
And for the petitioner, my lord. On the previous occasion, the respondent authorities were unable to produce any document with regard to.
Wanted time to effect service on the respondent
ma'am.
number 4.
I have already I'm filing my affidavit of service. My lord, kindly sees page 8.
Service is effected.
No, my lord. The door was locked in. My lord directed me to serve afresh. I've served on the address in the cause title as well as on the flat where they are alleging he's present and I'm saying he's not. So that also door was locked. My humble submission is that the door would be locked because the flat belongs to the Dev family, to the petitioner family, and we are in Assam. We come for the treatment of the petitioner number 3.
You want new connection?
Yes, my lord.
Mr. Sanyal, what is
essentially, well, he essentially wants a change in the name of the meter. Now, page 57 of their writ petition, Millards. On the day we had received application from the private respondent, we had gone then, inspected, and then there is a clear recording on our behalf that we found him in possession. So your lordship knows, even if the best case is he's a trespasser, so we provided him electricity. Now, if your lordship directs, we may process his application and go again. But the issue is, I need to find him in possession. Unless and until that is possible, it won't suffice. So that is.
Are you not required to have some documents also with the?
Yes. So for that, my lords, his one particular point was that Runudev passed away way back. Now I effected a change in name of the meter against Omlan Dotto in 2021, and I stated herein have received all formalities, including a no objection. Now I inquired what is the nature of this no objection exactly. In terms of Regulation 7, Millards, all of these applications are made online. There's an annexure A1 and an annexure A2. Now the applicant had provided, if I may provide, filled up those forms and also given name of 2 witnesses who are purportedly residents of the same premises. If my lords, I'm going to copy each. Check annexure 2, Sanjoy Ghosh, Uttam Das. So we, on a bona fide manner, proceeded on this. And also he submitted an affidavit, which is also required in terms of the rules.
No, but that means apart from the witnesses, this gentleman Omlan Kushum Dotto did not provide any independent document showing that
he provided the cases, if it is a case of a transfer after that person has died, obviously in the no objection certificate, no signature can be obtained. So in that case, the person wanting transfer needs to file an affidavit.
That Omlan Kushum Dotto is in occupation of the premises.
When we inspect,
he has a document to show that his address is that premises itself. In
Yes.
support of that, what document he showed? Because usually a driving license or gas bill or something of that sort is sought to be produced with the application which is being made for fresh connection. Or maybe Aadhaar card, PAN card, something to show that he has a documentary evidence of being in possession of the premises.
My submission is no, I don't. Such document.
I'm doing this. Who is the district engineer? I will direct you to the district engineer. The district engineer will take a call. If this gentleman is not able to provide sufficient documents, you will disconnect his line or maybe retransfer it back to the original position.
Original position, that person would be fair.
So whoever claims to be the heir, because he is definitely not the heir. Because he is not appearing in court, he is not to be found there. Serve notice. If he does not respond to your notice also, it's
fair enough.
In paragraph
action passed by Justice Kapoor upon the WBSEDCL authority to file a report whether the connection has been given. And now, Lordship, after the said direction, the WBSEDCL authority has issued us a letter to produce the SWID certificate for the said connection. Now, Lordship, we have challenged this before on this writ petition, the said notice. Now, Lordship, during pendency of the writ petition, they have went on to disconnect my electricity connection. But
Yesterday, I think a matter was,
yes,
yesterday I disposed of that matter.
there was a direction to take both the matters, Lordship, by Justice Kapoor.
It was not a direction to tag along with that.
Yes, Lordship, I have.
That matter has been disposed of yesterday.
Now, Lordship.
My lord, the player has become infectious. My lord,
Now, Lordship, what I, in the meantime, we later, sir.
His writ petition has become infructuous because your line has been disconnected.
Yes, but my line has been disconnected. This writ petition is still pending.
Your writ petition, you say what do you want?
No, Lordship. Lordship, kindly sees annexure P4 once. P3, Lordship, page 17.
P3.
This is the no objection certificate for power connection to applicant submersible pump.
You did not produce suite certificate is what they say. Yesterday they said.
Lordship, I have with the
8th April they were
the document that has been annexed to the petition. They have all the information, but still they have disconnected.
My lord, on 8th April there was joint inspection held on 6th April.
No, but
thereafter on 8th April they were directed to produce the page 15.
Page 17, what is this? Page 17?
17 is the suite. At that time they were unable to produce.
Petitioner was
on
respondent number 5.
They were directed to produce. They were requested to produce the suite certificate. Thereafter, on again and later has been issued on 4/6/26 annexure page 16.
Now, if they have this suite certificate on the ground of non-availability,
they were directed to produce the original suite certificate. My lord, the application is made in the year February 26, and the suite certificate is of 2004. Kindly see 6/4/18.
Yes.
Lordship, kindly comes to
what is the length of life of this suite certificate?
That is to be ascertained.
Then you are making submission, you have to say what is the life.
Lordship, kindly comes to annexure P2 once.
My lord, letter has been issued to them on 4/6/26 to produce the original suite certificate for authentication. Kindly see the page 16, last paragraph. Therefore, you are requested to produce original water level registration certificate at Notunat customer care for authentication within 7 days. They were unable to produce it. It is 4/6/26, and it has been disconnected on 9/7. After a month, within a month, they were unable to produce the original suite certificate. That's why.
To page number 14 once of the petition.
14.
Lordship, the joint field inspection report, the paragraph point number 3, Lordship. At the time of field inspection, no one of the consumers could not provide SWID certificate from geological department.
But
the respondent also did not produce, but their line is still there.
They could not produce.
Thereafter, they submitted.
Now, Lordship, kindly comes to the order passed by Justice.
On our demand, we send letter dated 8/4/26 to both the parties, and this private respondent immediately, just within few days, submitted the suite certificate. And the petitioner here did not, could not.
There is one more ground, my lord. Besides this suite certificate, is one more ground. If it falls within a semi-critical zone between two submersible pump, there has to be 200-meter distance. Milord will kindly come to their own annexure, Milord, at P3. P3, Milord, it clearly states the suite certificate. If I may read, motor rating of the said submersible pump will not be exceeded 3.5 horsepower, and the safe distance norm of 200 meters from the nearest shallow irrigation tube well has to be maintained. Milord,
where are you reading?
Milord, P3, Milord. P3, the para starts. Motor rating.
Yes.
Milord, motor rating para 2, Milord. The sentence starts as motor rating.
P3,
page 3, Milord, page 17.
P3 is page 15.
Page
17.
Page 17, Milord.
That is continuation of P3, yes.
Milord, the sentence starts as motor rating. Milord, motor rating of the said submersible pump will not be exceeded so and so, and the safe distance norm of 200 meters has to be maintained. Milord will kindly come to the inspection report at page 14, my lord. Inspection report says that the distance right now is 183 meters. Therefore, it is in clear violation of that suite certificate.
And Lordship, their connection also exists. Then within that one,
The subsequent one is to be disconnected. Who is
Exactly.
prior?
Lordship,
The subsequent one is to, I take connection.
Lordship.
And you take within 183 meters, and my connection will be disconnected.
Lordship kindly comes to the order passed by Justice Kapoor, page 19, Lordship.
Yes.
The second paragraph, WBSCDCL is represented and directed to file a report dealing with the grievance of the petitioner. WBSC will also furnish any ground if available as to the whether the electricity connection in favor of the petitioner is liable to be disconnected. At that point, they were also not able to produce the switch certificate.
Now they have produced. Switch
Lordship.
certificate they have produced. Switch certificate you have also produced.
Lordship.
So far as that criterion is concerned, fulfilled.
Lordship.
Now the next criterion is it has to be beyond 200 meters.
Lordship.
For the purpose of maintenance of water level.
Lordship.
Now, if he obtained electricity supply for his submersible
Lordship.
pump prior to that of yours,
Lordship.
then yours
What does-
should have been given beyond 200 meters.
Lordship.
If you have taken within 200 meters, yours is liable to be disconnected because at the first place you are not liable to get it.
Lordship, they have given the connection, Lordship, upon compliance
Therefore,
of all the formalities.
Again, Article 14 is not negative.
Lordship.
If they have committed an illegality, they cannot be asked to perpetuate the illegality.
Lordship, my instruction is that, Lordship, if it is advised, we will also remove the submersible pump from that place, Lordship, beyond the 200 meters.
As if they remove, we will consider.
Lordship.
Do it and apply afresh.
They may apply a fresh with switch certificate, or we can reconnect. We have.
He already has a switch certificate, and he will produce.
They did not produce the original to us.
We will produce
that.
Yes, we will consider.
Original is with the petitioner.
There is one more aspect, my lord. My lord, I'm not carrying the provision, but a switch certificate has a validity, my lord.
Very well, good. That will be seen by the authorities.
We have to see
My lord.
that point.
The petitioner alleges
am for the respondent WBACTCL, my lord. The last occasion, a bunch of documents was handed over. Your lordship asked me to take instructions. I think this is not the notification as my learned friend claimed. May I place the first page of the bunch of documents? The Government of India, Ministry of Power. It is a proceeding of the Rajya Sabha in terms of the rules of conduct of the Rajya Sabha.
Where are you reading? Where are you reading?
This is the bunch of documents.
Lordship, take this one, Lordship.
Last occasion they have handed over. Relying upon this.
Get back to
This is the Government of
This is
India.
a question answer. This is
Yes.
part of the notification. Lordship, kindly
How
go to the
it is
next page.
notification?
Lordship, kindly see the next page. I
May
got
I-
this printout from this
May I?
on question answer session from the Rajya Sabha. The notification has been placed between
Yes,
the
yes.
Rajya Sabha.
See the annexure. See the
Lordship.
annexure to that.
Kindly
Not the
see.
question. Yes.
Now, my lord, kindly see the first page. It is a question raised by member, then it has been answered.
Come down. Come
Good
down.
Lordship.
Dated 14th June 2024. This is a notification. It is not a question.
Yes.
F number 34/2016 trans part is a notification. It cannot be a question.
Kindly
F
see-
number is a finance ministry's
kindly
or
see
a
annexure.
file number.
Kindly head of the annexure referred in reply to part A and
Yes. So in the question, in answer to the question, they are referring to this notification. So this this notification is not an answer or a question. Notification is existing.
that notification has been, my lord, signed by the director of transmission.
Yes.
It is a guideline how the calculation will be made. Kindly may I place this? Kindly see. Ministry of, it is been a question was placed before the Rajya Sabha.
No, you need not read the first page. That is
Then,
not
my lord,
relevant.
then, my lord, kindly.
To the notification.
Yes, it is the Government of India, Ministry of Power, FA number 3426 transmission part. What is that? It is addressed to the Chief Secretary, Administrator of all state. Now, my lord, guideline for payment of compensation in regard right of way for transmission line. Now,
kindly come to the next page. Turn
Yes.
over the page.
yes,
Stop.
authority for determine the compensation.
Yes.
Now, the district magistrate, district collector, deputy commissioner is set.
Yes.
Now,
So
my
this
lord,
is we are
kindly-
here only. We are not going later on.
Now, kindly come
This is
to-
the authority. The district magistrate should
Yes.
determine the compensation. What is wrong in that?
No, kindly come the standard operating procedure, clause 10.
That how is that relevant?
That
here?
has been explained here, my lord. Can
Yes,
I
but we are
annex
not going to apply and determine. That is for the district magistrate.
That's
to do.
why now the question is, it should be under annexure 3 in terms of that guideline. That will be decided by appropriate authority, that is TSP, my lord. Technicals, kindly see page 8, annexure 3.
Where is page
Standard
8? There
operating
is no
procedure.
pagination here.
No, annexure 3, Lordship. It's
Annexure
Roman
3, page 8.
Pagination is not there, Lordship. It's
There is no
Standard
pagination. There is no pagination. So your page 8 is not.
Roman 3, Lordship. Annexure Roman 3, Lordship. Kindly.
Annexure
Standard
3.
operating procedure.
Yes.
Yes, identify landowners and issue notice to proceed by TSP. Collect document proof of identity and ownership by TSP. Verify the land records with revenue maps, official by revenue officials. This is the procedure laid down. What my learned friend had asked for, he has asked what that line has been passes through his land. Whether it has been passes through his land or not, that will be decided by this process, not by according to his wish. Now, my lord, what we have done.
So what he submitted is my wish. That's why I'm coming
We are
before the
unnecessarily
requesting my
expanding this.
money of the petitioners.
The only question which court wanted to know is who is the authority, to whom it is to be referred. The manner in which it will be decided, how it will be decided, it is not our headache.
Then, my lord, kindly district magistrate be.
So that was the question. Unnecessarily you have.
He has, my lord, asked for compensation because we have already paid some.
No, lordship, it's not
You have
for
paid some, you will be entitled to go and say that to the
What we have
land
paid?
damages.
We have paid for stagging.
Lordship, kindly come to the annexure.
Please wait, let him conclude.
What we have paid for stagging the materials on his land. That's why we have paid compensation.
Very well, we are not going into the merits.
Yes.
I am not here to decide that.
Yes, my lord.
Even on the first day, I did not say that I want to decide this. I said that he is the authority, she should approach this authority. But you wanted to object to this, I don't know.
My lord, he placed that according to that he has asked the
No,
compensation.
that was not the court's query. She might have
Yes,
made the submission.
because as
I
was
wanted to tell you that district magistrate is the authority. It should be referred to the district magistrate.
yes, because
That
my lord,
problem I
his
don't understand.
His submission was that he asked for 200%.
Whatever may have been the submission.
No,
the
I never said
question
that
which
200%
fell from
I
the
was.
court was
As per the
district
guidelines
magistrate
that
is
we
the
played for.
authority.
Yes, then refer to follow the guidelines.
No, lordship, kindly come to the annexure 3, lordship, the notification.
Yes.
The last 4 lines, from bottom 4 lines, lordship, DM or the authorized executive magistrate to fix compensation. The district magistrate, the fee is just.
That is what I was also saying. It has to go to the district magistrate for him to fix compensation in terms of this. Where is the problem?
I don't know, this is his problem.
Only one thing is the guideline, the first page of the guideline. It says this is the guideline. Admittedly, this is the guideline. Now it says that states may adopt these guidelines in its entirety or issue their own modified
First
guidelines.
page, where are you reading?
The first page, the last line of the first paragraph. The answer, the first page.
First page means
Yes,
this.
yes.
Why are you reading? This is
No, why?
question answer.
There is
It's not binding.
States may adopt. What says states may adopt these guidelines?
That's not binding. Do you mean to say that you have not adopted this?
No, I am not
That
state. I am
doesn't
saying
say
whether it has been adopted or not. Now kindly see the next page, the notifications part, paragraph number 2. It refers to section 67, 68 of the Electricity Act and read with sections 10 and 16. So only what I am indicating, if you losses kindly see section 16, the power is with the district judge.
That's right. The power is with the district judge, that is known. But if the guidelines say that it has gone to the district magistrate, then I can refer it.
It's not about the
Guideline, what the district magistrate.
Do you mean to say that the state has not adopted it?
State can say.
Who is appearing for the state?
The first thing is this issue is this whether at the time of extending the waves, whether the petitioner got their necessary compensation or not. If that issue persists, if that issue is not redressed, the adjudicating authority is the district magistrate who shall take a decision.
No, under the Telegraph Act, the authority is district judge.
Yes, your lordship.
Not the district magistrate.
Yes, your lordship.
Now, this guideline will not override a statutory provision.
Yes, your lordship.
It has to go to the district judge. Now, then, what is the relevance of this guideline then?
But let's see.
Lordship, in this regard, may I submit one, Lordship? Regarding Telegraph Act, may I submit one thing, Lordship? The Telecommunication Act came into force on 24th December 2023 and it repealed the Indian Telegraph Act 1885, the Indian Wireless Telegraph Act 1993, and Telegraph Ware's Unlawful Possession Act 1950.
Show me what are you reading?
Yes, Lordship. And according to this Act, Lordship, Section 56 empowered the central government to make the.
This may be relevant. If it is according to that, and that has been.
It has been, my lord, that saving portion, that 164 has been saved. Kindly see.
Madam, which provision were you reading?
Section 60. I am Lordship. Lordship, kindly come to section 56, Lordship.
56.
Yes, Lordship. That empowers the central government to make the rules, Lordship.
Section 56. Yes, central government will have. But this is not rule. This is an executive instruction.
Yes, Lordship. That empower.
Rules will be different.
Kindly come to section. Kindly come to page 47 of this. 47 of this books.
Page 47.
Page 47. The telecommunication right of way rules and chapter 5.
Page 47, yes.
Yes, Lordship, chapter 4, this is middle portion. Lordship, kindly go through.
Chapter 4.
Chapter 4. 5, Lordship.
5, yes.
Establishment telecommunication network in property other than the public property. On the basis of this rule, guidelines has been issued, Lordship.
But this guideline does not refer to this act at all. This guideline only refers to Electricity Act and Telegraph Act. Therefore, even if it has overridden this guideline, it may be overridden for the purpose of telecommunications, but for the purpose of Electricity Act, the Telegraph Act will still apply.
Yes, Lordship.
Section 60, my lord, say section 60 of that telecommunication.
Not relevant.
Guidelines
Guideline also refers to the Telegraph Act.
A guidelines specifically says
even in section 16, my lord, the district magistrate has some power. If you can you see section
Lordship, kindly see.
subsection 1.
Specifically, guidelines that says that the district magistrate is the authority, Lordship. And kindly see the clause 5, row corridor compensation.
Telegraph Act.
Compensation পেতে পারে। And it will be decided.
Yes, district judge under section 16, subsection 3.
Yes.
District judge is the authority.
But district judge, Lordship, district magistrate is also there. He first issue the notification. Lordship, kindly see.
But this notification cannot override this section.
After, no, that's true, Lordship, but I have made the prayer for the compensation on the basis of these guidelines. Lordship made prayer before them and they're still tight over the matter. So I'm only praying for this.
You have made prayer before the DM.
Yes, Lordship. And Lordship, kindly go.
Consider it. She has made the prayer. What is the
Yes, my lord, DM will decide whether it has been passes through his land or not.
Whatever.
Then auto question of compensation will arise. If it is not passes through his land, then question of compensation does not arise.
What I am trying to submit before your lordship, that some inquiry is necessary.
Yes.
And the DM can conduct that inquiry. The district judge cannot.
Very well, let the DM decide it. The petitioner is aggrieved by the non-consideration of the petitioner's representation dated February 19, 2006. That is the date, madam? 19 February.
19 February 2026.
February 19, 2026. Made by the petitioner before the district magistrate, Paschim Bardhaman. You have sought for compensation also?
Yes, sir.
Seeking compensation for damages incurred by the petitioner due to drawal of overhead high tension line by the respondent numbers
2, 6 and 7, Lordship.
2, 6 and 7.
And 4 also, Lordship. 2, 4, 5, 2, 4 and 6, 7.
2, 4, 6 and 7. Full stop. Paragraph. Learned advocate appearing for the petitioner submits that despite such representation having been made on February 19, 2026, the district magistrate has not taken any decision thereon, and the petitioner has been left in the lurch. Full stop. Paragraph. The petitioner relies on a notification bearing F number 3/4/2016 hyphen TRANS T বড় হাতের hyphen part PRT part within bracket 4 dated June 14, 2024, issued by the Government of India, by the Ministry of Power, Government of India, to assert that the district magistrate is the authority for determination of compensation in cases of drawal of high tension lines, full stop, paragraph. Having heard the learned advocates appearing for the respective parties and having considered the material on record, comma, this court does not find any reason to keep the writ petition pending, full stop. The district magistrate, comma, Paschim Bardhaman, is requested to consider and dispose of the petitioner's representation dated February 19, 2026, within brackets Annexure P3 at page 22 to 25 of the writ petition as expeditiously as possible, and preferably within a period of 8 weeks from the date of communication of this order, full stop. The petitioner shall be entitled to produce all relevant documents and evidence in support of the petitioner's case before the district magistrate, full stop. The district magistrate shall also hear the respondent West Bengal electricity transmission
West Bengal State Electricity
West Bengal State Electricity Transmission Company Limited and
Transmission Company Limited, Lordship.
Yes, Transmission Company Limited.
Lordship.
And Kalpataru Projects International Limited. Before taking any decision, full stop, the the district magistrate shall have due regard to the notification dated June 14, 2024, full stop, paragraph. With the aforesaid observations, WPA 14686 of 2026 stands disposed of, full stop. Needless to mention that this court has not gone into the merits of the petitioner's case, and all points are left open to be urged before the district magistrate and decided by the district magistrate in accordance with law.
Record only one submission, whatever compensation is due and payable, we have paid them.
Whatever payable, Lordship.
Very well. His submission. Mr. Nag, learned advocate appearing for the respondent number 6 and 7, submits that whatever was due and payable to the petitioner has already been paid. However, comma, Mrs. Nag, learned advocate appearing for the petitioner, refutes such contention. এটা উপরে লিখে
ওনাকে বলতে যে একটু অপেক্ষা হবে নোটিফিকেশনটা
I am applying for the state respondents.
Affidavit of service. Affidavit of service.
Second service, I am a toll lot as given a judgment with Para 19 of this.
Avoiding the service.
They are avoiding the service, but not sued. They are not.
Yes, and who are you in respect of the premises? Tenant.
Tenant.
And the person who is obstructing, landlord.
That's 7 and 8.
On that day, it was recorded on 22nd July. Service on respondent number 7 and 8 is still not complete.
Yes,
service may be completed
by
in the
toll lot. Subsequent affidavit service I have submitted. I have the photocopy with me.
On what date you submitted?
Now,
Okay.
7, 8 landlord.
The last, you have submitted two affidavits of service.
Yes, yes. I have the photocopy of the second affidavit service, page 15 of that affidavit service. It was second, right?
second.
Yes, yes. Second.
Oh, you have not yet understood. Show him. Service was not completed because it was out for delivery. It has to either return to you. It was not completed as yet. That is the recording. You have to take out the track record after that date and file an affidavit of service.
This is the one.
This second affidavit of service was taken into consideration on 22nd July when the order was passed. Please read the order on 22nd July. এটা ওনাকে দিন।
সেকেন্ড অ্যাফিডেভিট সার্ভিসটা কবে হয়েছে?
হ্যাঁ, করা হয়েছিল।
হ্যাঁ, করা হয়েছিল। তারপরে ওরা
বিকজ লাস্ট এইটাই করলো। হ্যাঁ, সেটা সাবসিকুয়েন্ট
ওই অর্ডারের পরে কি সেকেন্ড অ্যাফিডেভিট সার্ভিসটা হয়েছে?
Sir, all you have to do is to take a fresh printout from the postal track department. You will get it. That was told to you on the last occasion also. We are at the same position again.
Last occasion, my lord, due to no adversary and no order has been passed, my lord.
No. I remember I told you that you have to take fresh printout to show that it has returned to you. Because it is inconclusive.
ট্র্যাক রিপোর্ট বার করতেও আছে কিনা দেখো মোবাইলে।
I have taken a fresh printout, but this is not a evidence service. That is status delivered.
I am keeping it tomorrow. Bring the affidavit of service. এটা কালকে নিউ মোশনে দিয়ে দিন। লিখে নিন, একটা অর্ডার লিখে নিন।
বারবার জিজ্ঞেস করছি।
Affidavit of service is
I appear on behalf of the petitioner, my lord.
yes.
We've prepared a report after inspection. We are agreeable to provide him with a new meter, subject to compliances. Only one observation: the existing meter board position is on the outside. So in the report, we have advised that if that could be covered to avoid safety, avoid fire and other hazards for safety reasons.
Nobody is appearing for the private respondent.
No, already solved the problem.
ঠিক আছে, এটা লাগবে না। লিখে নিন। None appears.
up on Monday. Because of that, today and tomorrow and day after tomorrow, I have some
Item 42,
item 42 and 58.
item 42 and 58 সোমবার করে দিন।
Grateful, Your Lordship. 42, 58.
58 সোমবারের ডেট দিয়ে দিন।
Grateful, Your Lordship.